Yes, sir. Thank you, Vijay Bhai, Keval Ramani ji, for your continuous efforts for sharing the knowledge in this period of Corona. We welcome you all, friends, on behalf of all the organizations who have joined hands to organize this webinar. And the topic, as we are all aware, is very important: natural justice and other issues in reassessment, where thousands and thousands of cases are going on in litigation. Today, our chairman is Dr. K. Shivram, designated by Bombay High Court as senior advocate. He has served as president ITIT Bar Association Bombay and also as our president of All India Federation of Tax Practitioners. He is a prolific writer and admirable orator. We all respect Shivram Saab, and we would like to listen your chairman's remarks in the beginning for at least 15 minutes. Dr. Shivram Saab.
Thank you. I want to speak.
Okay. Welcome, sir. Good morning.
Sir, you can start. Shivram sir.
Shivram sir, please unmute your mic.
Okay.
Now, okay.
Okay, are you able to listen to me?
Shivram sir, yes. Please.
Okay, thank you. Thank you. First of all, you know that.
Yes, sir.
Good morning to all of you, all the participants. So thank you very much for the giving an opportunity to share the very important subject, which is moderated by Mr. Narayan Jain, one of the author in one of the very good publication, How to Handle Income Tax. And also we are having, one of the very learned speaker, Mr. Goel, had occasion to chair one of his sessions long back in the federations. Now let me share with you that and let me congratulate Mr. Ramani, J.K. Ramani, for selecting the subject for today's discussion, that is natural justice and reassessment. Why I say that it is a very important subject? Because it is a day-to-day subject, and according to me, after your lockout will be lifted, many of you may have to face a lot of issues connected with the reassessment proceeding. Therefore, it is a timely subject, and it is, we are having a good speaker and moderator. According to it, is very interesting, all of you. So let me also wish like Mr. Nankani, Vice President, is participating in this, that webinar is concerned. Thank you very much, Nankani, for participating. In fact, that the subject is divided in two parts. Mr. Goel is going to discuss. One is natural justice. In fact, this is a subject very important. The natural justice is concerned. In fact, that today, before I go, let me share with you. In Mumbai court today, when we go on the writ petition, 80% of writ petition only on the reassessment last year, possibly this year also. And another 5% will be only on the recovery, and remaining 15% other. That shows the very important of this today's subject is concerned. Now coming to the natural justice, I may share with you only one or two judgments only just for discussion. I think Goel will discuss further. One is, A. Kanakpak versus Union of India 1976 Supreme Court 150. This is the term. The aim of the rules of natural justice is to secure justice to put in negatively to prevent miscarriage of justice. The whole purpose of the, the whole purpose is that the miscarriage of justice should be avoided. Now, in income tax is concerned, we will find 26 ITR 775. Nakeshwar Cotton Mills, we said that where principal interest is violated, like Supreme Court set aside the assessment. And we will find the leading judgment in our income tax, that is the 199 ITR 530 Supreme Court, that is C.B. Gautam, where he laid down that natural justice violation may lead to the violation of fundamental rights, Article 14 and 21 of the Constitution of India. Then you will also find, that the Supreme Court 176 at 169, that is Shivram Durga Prasad, order passed by the officers or the authority, violation of the principle of justice is nullity. They go on to this extent till amount to nullity is concerned. Therefore, that the how important is the natural justice. You will be able to understand when we go into little more and when we discuss the issues on natural justice concern. Now you will find the Supreme Court in our one of judgment, that is in Andamana Timber, that is the reported in 127 DTR 241, where he says that the denying opportunity cause examination in their order is nullity. And you all may be aware that the 125 ITR 73, the Supreme Court held that the authorities cannot use the statement without giving opportunity. This is in basic principle that will apply. All given the reassessment, assessment, everything will apply. Now, only thing is, as we are having, like the Mr. Narayan also mentioned, Goel also will refer it. When I was going through the last year's reported cases, what I find about more than 250 cases of the High Court judgment only on the reassessment. Another 250 of the tribunal judgment reassessment. Therefore, the total 2,000 cases reported, you'll find more than 1/4 is only on the reassessment. Therefore, we have to understand the importance of the area's case law. But let me share with you before going to the judgment. I will refer to only one judgment of Supreme Court, that is Oriental Insurance, Rajkumari, AIR Supreme Court 403. That laid down the principle that how to read the judgment. Because you see, many times what I find that when you argue before the tribunal, I come across some of the, some of the young practitioners, when the members asked you that which are the case laws, they go on giving the judgment, and members ask you what is the ratio of it applicable to. They are not able to explain properly. Therefore, we should know before we rely upon judgment, the Supreme Court said that you read the judgment in the context which has been given, what is the ratio, how it applicable facts of your case. Then only it should be able to apply. The same principle laid down in the 198 idea 297, that is the Sun Engineering is concerned. Now we'll find the after this, that this is the as regards readiment of judgment is concerned. Now you are aware that later judgment of Supreme Court, that is Mr. Goel is maybe going to New Television Limited, now reported 116 Taxman 151 Supreme Court. They left it various. Now we have read the judgment before we argue any matter on reassessment is concerned. The Supreme Court laid down about the 7 to 10 principles on that, which I will not discuss what are the principles, because Mr. Goel is the right person to discuss on that. I think in the course of the discussion, the Goel will discuss that are the 7 to 10 principles, and thereafter we will look into the other issues are concerned. Now that the one point which I thought of sharing with you, so Mr. Goel may discuss the how far the judgment is applicable to future matters which we had argued for the various benches of the High Court or Tribunal, and what are the ratio of the judgment and how we can utilize for our pending assessment is concerned. Now because within the time allotted to me, let me discuss with you 2-3 issues of the practical issues which may be relevant for the the tax practitioners, those who are practicing across the country. First of all, what in my limited practice I come across that what I find the most of the reply what we give in pursuance of the 148, when they give the recorded reason, that is not very satisfactory. So if it is reply what you file objection is not satisfactory, when you go read to the High Court will ask a very pertinent question, where is your submission before the ITO on this. And where is your, now we are raising new ground, which will not allow you to raise at all. Therefore, my advice will be all these cases that all those consultants who are dealing with that, when you give the reply to the 140 recorded reason, try to cover almost all the issues like your sanction is concerned, like your non-application of mind is concerned, what change of opinion, all these technical issues and practical issues which you have to raise. Once you raise it, by assuming if he doesn't deal with that, and when you go and read, then chances of your success is very better. Now, one more thing possibly you may have to consider. Let us say while dealing with the 148, the issue is fully covered by, let us say that the judgment of the Supreme Court or judgment of the Judicial High Court. Try to refer the judgment in the reply. So therefore, that when officer deals with that, then he has to deal with that how the judgment not applicable to. He cannot say that I will not follow the judgment. If you say that we will not follow the judgment, that may not contempt is concerned. Because there are judgment in the which when we concluding, I may give the citation for that. He says that if the officer, though the appeal is pending in the Supreme Court, if the officer doesn't follow the judgment of Judicial High Court, it may lead to civil contempt. So therefore, it is desirable to reply all that while in the reply is concerned. Now, lastly, one more point which I thought of sharing with you, what I have come across many a time, the consultant give their email address when they notice to be sent. Possibly it may not be desirable to consultant to give their email address. By any chance he gives the email address, notice come to the consultant, if it doesn't appear before the officer or doesn't file it, then may ultimately may lead to the ex parte assessment. Then finally, let me also share with you, which I must have shared with many times earlier. What I find that many of these, when the 148 notice comes, the SSC write that instead of SSC, consultant write the whatever return filed earlier may be treated as a return in pursuance of the notice under 148. My advice is that it is not the correct reply. If at all you have to do, ask the SSC to file the return in pursuance of 148. And if at all that they don't want to file the return, then let SSC write that whatever return filed, it may be treated as the pursuance of the 148. Reason being, I'll tell you, tomorrow by any chance, the return turned out to be bad, or it has turned out to be something, huge addition is made. And the client may take the view that, no, I have not signed the return, signed by consultant, so that I should not prosecute it. At least the addition may be justified, I should not prosecute it. So with this background, I thought, that is the what allotted time. I have completed my 15 minutes. And, finally, when the opportunity comes, we'll discuss some of the issues. And with this, hand over to Mr. Jain, moderator. Jain, please carry on.
Thank you, respected Dr. Shivram sir. And we are looking forward to listen again in your concluding remarks or in question answer session whenever you want to kindly supplement. So with this, we come to the learned speaker, Mr. Kapil Goel. And all of us know him, but still for the sake of my job, I would like to briefly introduce dear Kapil Bhai.
Thank you, sir.
He is our young advocate, BCom honors, FCA, and a practicing advocate. His expertise lies in direct tax litigation and research, that is prompt in-depth analysis of the latest case laws. He has represented in more than 1,000 cases in various forums, including ITIT, High Court, and Honorable Supreme Court. He is a wonderful orator and has addressed more than 2,000 seminars across India, as well as many webinars. And in such many of the seminars, he had the privilege of sharing the dais with honorable judges of the Apex Court and High Courts, as well as tribunal members. He is my colleague as a member of Direct Tax Representation Committee in AIFTP. He is a prolific writer. His articles are carried in Taxman, ITIT Online, Punjab, PhD Chamber of Commerce, TIOL, and also the Institute's magazine. And he has been also given various awards. I need not mention it. And his best introduction is his presentation, which he is now going to do. And Kapil Bhai, we are proud of you and we welcome you. We are all eagerly listening all over India to listen to your incisive views on various dimensions of reassessment proceedings. Welcome. You may kindly begin.
Thank you, sir. Thank you, Narayan Bhai. And when I say Bhai, sir, I say in Mota Bhai sense, sir. So I always receive lot of blessings from all my seniors and including Shivram Saab. I have huge regard for him. He's always a great harbinger, and I can say, sir, proponent of the justice, sir. In the administration of justice should remain pure. The reverse of administration of justice should remain as pure, and it is a matter of a great, again, honor, sir. Always when I look, have the erudite company of yours, sir, it is a matter of special blessing to me that God is blessing, and so many people, sir, Srivastav Saab, Bibi Gupta ji, Kakra Saab, and everybody, Keval Ramani Saab, and everybody, sir, I'm not taking the name. I have the chances to interact with all my colleagues, majority of the colleagues here, sir, and majority of them are senior and they are like in the parental figure to me, sir. So it is always a matter, sir. We always learn, Shivram Saab, and it is like this, that you have rightly set the tone, that and when you have made this interesting and very pointed statistical analysis, sir, that how many cases in the litigation are, I can say, not in pejorative sense, but in humble sense, that how many cases in the litigation are infected by the or are on the ground of infraction of a healthy principle of natural justice, and how many of them are relating to section 148 as far as income tax litigation is concerned, Jain Saab. So definitely this statistic analysis which you have presented, sir, eruditely, it is very important that when this administration of tax administration conducts the proceedings, sir, and we don't discourage that the proceedings should not be conducted in e-manner, sir, digital manner, but at the end of the day, sir, principle of natural justice, as we have learned with our seniors, with our experience in the courts, that it is natural justice. I believe when Adam was there, God has given principle of natural justice to Adam also. Before taking a view, God has given. So I remember that thing, sir. So if we take in that sense, then principle of natural justice are deeply rooted in our Indian jurisprudence, sir. And as far as Holy Indian Constitution is concerned, and as you rightly mentioned, that especially Bombay High Court has been very, very important, taking in harbinger role, sir. And as far as proponent of principle of natural justice is concerned, and especially in writ petition, sir, writ jurisdiction. So that is, I will come to, but just I am giving my prefatory point, sir. The number one thing is this, sir, that as far as natural justice is concerned, it is deeply rooted in our jurisprudence. Even Adam, I said, sir, our Indian ancient Indian material and jurisprudence says that without principle of natural justice, no proceedings can be conducted. And if I go to Article 21 of the Indian Constitution, sir, which is the bone marrow of the case, sir, which is the bone marrow of the entire thing. Anwar sir, please allow me to keep my point in my manner, sir, please. So what I am submitting is, sir, that Article 21 of the Indian Constitution, sir, clearly says that any procedure has to be fair, reasonable, and equitable. So Article 21 of the Indian Constitution, Supreme Court decision in case of Menka Gandhi, sir, the leading decision of 9-judge bench. And it is very important, sir, we keep in mind that principle of natural justice is so natural that it is so deeply rooted in our Indian jurisprudence. That is what I am trying to point out before coming to case specific, sir. That Article 21 of the Indian Constitution very clearly says any procedure of law has to be reasonable, has to be fair, has to be equitable, sir. And that is what, sir, when Supreme Court gave the leading judgment in the case of Menka Gandhi, the passport case, sir, the importance and significance of principle of natural justice was amplified. And that is what I am saying, sir. Income Tax Act, as far as provisions of Income Tax Act is concerned, Shivram Saab, since you are my chairman, it is very important that and it is my habit, sir. I will just address you, sir, so it can.
No, absolutely no problem.
So point is this, sir, that as far as Income Tax Act is concerned, I have 7 or 8 Supreme Court rulings or High Court rulings, which I am going to narrate now on principle of natural justice in Income Tax Act. And where, sir, firstly, the Supreme Court decision 5-judge constitution bench in case of Surajmal Mohta, 26 ITR volume page 1. 26 ITR volume page 1. Now, this was the ruling of Supreme Court in 5-judge bench, sir, where Supreme Court constitution bench clearly said that principles of natural justice are not excluded in Income Tax Act. They are integral part of the Income Tax Act, and income tax authorities are duty bound to comply with the principle of natural justice. I believe this is one of the most initial order when that commission was framed, sir. You remember in old days, Surajmal Mohta, and it was a very famous case, sir. Supreme Court clearly said, 5-judge bench, that principles of natural justice are not excluded from Income Tax Act. Citation, I am repeating, 26 ITR volume page 1. Sir, then after that, even latestly, the Supreme Court of India speaking through 3-judge bench, sir, in the case of Sahara India. Why this important, this ruling of Sahara India is important, sir? We will recall that there is a provision in the Income Tax Act dealing with special audit under section 142 subsection 2A. And there, sir, it was a controversy before the amendment by Finance Act 2007, whether before proposing special audit, principle of natural justice are required to be followed or not. That is, assessee concern has to be given opportunity before special audit is being ordered, sir. So, section 142 subsection 2A, before the amendment, the Supreme Court in the case of this Sahara India, sir, 300 ITR 203. Now, this is a 3-judge bench order, sir. 300 ITR 203, considering entire conundrum of the jurisprudence, Shivram Sahab, and saying very clearly that unless principles of natural justice are excluded, it will be always treated that they are part of the legislation, sir. So there is nothing in the Income Tax Act which I want to say firstly that principles of natural justice are nowhere excluded. They are integral part of the Income Tax Act. That is why I gave these 2 rulings, sir. One 5-judge constitution bench, and second this 3-judge bench, where Justice D.K. Jain was speaking for the bench in the case of Sahara India. And there he has very clearly written that principle of natural justice are part of the Income Tax Act. And wherever any civil consequence is arising, any consequence is being inflicted, civil consequence, then it is important that the affected party is being given principle of natural justice, sir. So I will also narrate at the outset, sir, because this is a very landmark order. Third ruling, sir. I thought it is not reported in the income tax journals, but it is reported in SCCs and some other decisions. The name of the case can be noted, sir. Sona Builders. Sona Builders versus Union of India. Now, Shivram sir, this Sona Builders versus Union of India is a Supreme Court decision of 3-judge bench. And it was an issue, sir. This is not reported in the ITR, etc. But this is available, and in my notes also I have talked about it. Now, what is this ruling of Supreme Court in Sona Builders versus Union of India, sir? This was a case, sir, where purchase of immovable property and this clearance of immovable property, you remember in section 269U, etc., was in issue. Now, one notice which was given to the assessee, that is the affected party, show cause notice. It was not complete notice. It was vague notice. It was not containing all the things, sir. So 2 points Supreme Court 3-judge bench, sir, noted. I am giving crux of the order that if the notice which is being issued to the assessee, it is not containing can these proceedings be set aside, Narayan Jain Sahab, to the department for one against, thank you, Saurabh Bhai. But this is, I believe, Sona Builder. This is different Sona Builder, sir. I am talking about some Sona Builder different, maybe. You can check. This is the same order, section 269U, 3-judge bench, Justice Y.K. Sabharwal bench was there. Now, Shivram Sahab, in this case, what was happening that when the department took this argument before the apex court, ki sahab, you should set aside this case to the department AO again, adjudicating authority again, because even if principle of natural justice is violated and we have not given proper notice, then we will now give it. Then, sir, Supreme Court gave a very important point, sir, which must be noted. Ki when the proceedings are to be completed in a given time frame, and if it is to be completed in a particular time frame, thank you, Tibarwal sahab, then there it is very important, sir. If the natural justice is not given in that before that time limit, then second innings will not be granted to the revenue to improvise its case. So this is very important point, sir. Supreme Court very clearly in Sona Builders, in the last penultimate paragraph, has very clearly by 3 judge bench, and I'm saying it is a 3 judge bench order. And there they have said that we will not remand back, sir. The proceedings will be quashed and no set aside will be done. Shivram sir, this is the ratio of this order, sir. So what I want to drive home here is, sir, that yes, principles of natural justice are deeply enrooted in the Income Tax Act, and Supreme Court of India at multiple occasions have recognized and acknowledged this fact, right from Surajmal Mohata, then to this Sahara India, and then to this Sona Builders. And sir, if I say in other sense, then all these orders of Supreme Court are starting with the name with the alphabet S. It is a coincidence. So what I am submitting is, sir, that principle of natural justice, and yes, now principle of natural justice is again taken to a next level. If I talk about this ruling of Supreme Court, sir, which I just gathered, in the case of, sir, one can note this name of this case. It's not income tax law case. It's a case of another. It's a case of other law. But this is very important judgment from today's point of view, sir. The name of the case, sir, which I want to just tell is, sir, Nawab Khan Abbas Khan, sir. Nawab Khan Abbas Khan. Now, sir, this ruling of Nawab Khan and Abbas Khan was authored by Justice Krishna Iyer. And this is a Supreme Court order, Nawab Khan Abbas Khan, sir. And in this order, sir, Justice Krishna Iyer, his lordship in his own style, has said that there is legion. Legion means there is an abundance of jurisprudence on principle of natural justice. But yes, he says that, and he has written that if a right is granted in a statute, that assessee will be given principle of natural justice, and if it is not given, then whole order will be nullity. So finding of the Supreme Court in Nawab Khan Abbas Khan, later noted by Justice Khanwilkar in case of Bharti Reddy. This order can also be noted, sir, Bharti Reddy. Justice Khanwilkar has noted this ruling of Supreme Court, earlier ruling, and said that if principle of natural justice as guaranteed, right, in constitution and statute is not followed, then entire order, sir, will be nullity. So I want to just take a break, pause here, sir. Principle of natural justice are nowhere excluded in the Income Tax Act. They are integral part of the Income Tax Act, and rather, if I go to, sir, section 143 and 142, which deals primarily with assessment, section 143 and section 142, sir. Both of these provisions, which deals with the procedure of the assessment, sir, in the Income Tax Act, has specific inbuilt criteria that assessee will be confronted with the material gathered by the assessing officer at the back of the assessee. Now, sir, everything, Anwarji, is in my notes. Don't unnecessarily, there is everything in my notes. Please let us concentrate what I am discussing, sir, so that we can drive home the point, sir. You can just note the name, and otherwise also I have already given 10 questions that is there. So point is this, sir, that when I talk about section 142 subsection 3, Shivram sir, this is a very important provision in income tax assessment chapter, section 142 subsection 3, sir. What this section propounds, sir, is that if any material is gathered by the assessing officer at the back of the assessee, and it is not an assessment framed under section 144, then assessee officer is under a duty. He shall confront that material to the assessee before the assessment is finalized, sir. So 142 subsection 3 is a specific statutory prescription, sir, saying that any material which is gathered by the assessing officer at the back of the assessee has to be confronted to the assessee for its rebuttal. Now, this is specific recognition to principle of natural justice. If it would not have been there, still this would have been followed, sir. But yes, the effect of section 142 subsection 3 spirit is, in my opinion, is this, sir. If something is done by the assessing officer in the assessment in violation of 142 subsection 3, then it has to be expunged from consideration. It has to be excluded and eschewed. So 142 subsection 3 has been taken note by many tribunal decisions, sir, latestly, especially Kolkata bench decisions. That 142 subsection 3 is a very important principle of containing a very important principle of natural justice, and it has to be very strictly followed, sir. Proceeding further, sir, even when 143 subsection 2 and 143 subsection 3 are noticed, sir, even there, sir, one will find that principle of natural justice has to be followed. Even we consult section 143, sir. So any material gathered by the assessing officer at the back of the assessee has to be given to the assessee, sir, has to be confronted to the assessee. And that's why, sir, Supreme Court of India has ingeminated and has emphasized very seriously that something is there with the assessing officer, which he has gathered from, let us say, investigation wing, which he has gathered from various discrete inquiries, whether he has taken it at the back of the assessee by inspector report, etc., etc. In all these cases, sir, assessing officer is under a duty to share that material with the assessee and to confront it, and by a proper show cause notice. This is my next limb, sir. Now, in principle of natural justice in the Income Tax Act, sir, we see a lot of time the show cause notice which is being given to the assessee is not up to the mark. As I have learned in my practice, sir, show cause notice is a show cause notice which gives me a charge which I have to meet. There are two important ingredients in any show cause notice in any law. Number one, what is the charge against me and what is the basis of that charge? If either of these things is missing, sir, either charge is not there or the material on the basis of which charge is created is not there, I believe show cause notice will fall and crumble. So requirement of show cause notice, sir, I want to signify, and please, when you come, Shivram Sahab, the point which I want to highlight is the importance of the phrase reasonable opportunity of being heard. In Income Tax Act also, sir, this phrase has been used in multiple places. Reasonable opportunity of being heard will be given to the assessee. In 143 also it is there. In 148 cases also it is there. I said in almost all the adjudications to be made by the Income Tax Department, reasonable opportunity of being heard is an important statutory prescription. Now, sir, what is there in reasonable opportunity of being heard? And this is again, sir, I did not knew earlier in my study and in my preparation for this seminar. I found this order and I found what a order it is, sir. Justice S.B. Sinha is the author of this order of Supreme Court. And the name of the case is, sir, on the principle of reasonable opportunity of being heard. What 6 points should be there in any principle of reasonable opportunity of being heard, sir? The name of the case is, sir, Sohan Lal Gupta versus Asha Devi. This is Sohan Lal Gupta versus Asha Devi. The date of the order is, sir, 1st September 2003. Sir, I have not seen a better enunciation on the word reasonable opportunity of being heard. What 6 criteria it should contain, Shivram sir. Now, I'm spelling out for the sake of completeness, and it will cover entire conundrum of natural justice, sir. Sohan Lal Gupta case of Supreme Court, authored by Justice S.B. Sinha. First point, the Supreme Court says each party must have noticed that hearing is to take place. Number 1. Number 2, each party must have a reasonable opportunity to be present at the hearing together with his advisors and witnesses. Number 3, each party must have the opportunity to be present throughout the hearing, throughout. Number 4, each party must have a reasonable opportunity to present the evidence and argument in support of his own case. Number 5, sir, each party must have a reasonable opportunity to test his opponent's case by cross-examining his witness, presenting, rebutting evidence, and addressing the oral argument is also addressing oral argument. And last one, sir, the hearing must, unless the contrary is expressly agreed, be the occasion on which the parties present the whole of their evidence and argument. So I want to submit, sir, the reasonable opportunity of being heard is a very important phrase as amplified in the Supreme Court decision. And there is another decision, sir, where Supreme Court, Justice P.N. Bhagwati was the author of this order in case of K.T. Shadulli versus State of Kerala. K.T. Shadulli versus State of Kerala. Again, sir, a sale tax law provision was there, but the language of that provision is pari materia to analogous and homogeneous to the Income Tax Act. And Justice P.N. Bhagwati, a 3-judge bench of Supreme Court, sir, said that the reasonable opportunity of being heard, Shivram Sahab, includes opportunity of being cross-examination also. So reasonable opportunity of being heard means proper opportunity where effective hearing is given to the party concerned to meet his case and to present his case. And secondly, which includes cross-examination also. So in my humble opinion, reasonable opportunity of being heard is a very wide phrase, sir, which covers entire baggage of the natural justice rights. So somebody asked me where is this cross-examination is coming from, where this opportunity of confrontation, etc. is being coming from. The reasonable opportunity of being heard is a very important phrase, sir. And then, sir, I believe show cause notice. Sir, I said in lot many cases, Shivram Sahab, we have seen in our, as you have also said, that when income tax authority gives us show cause notice, either the charge is not there, clear charge, or the charge is wrong, or the charge is not based on intelligible and rational grounds. Now, in my humble opinion, reasonable opportunity of being heard also requires a show cause notice should be given before adjudication is made. Requirement of valid show cause notice is emphasized, sir, by the Central Board of Direct Taxes in its instruction number 20/2015. CBDT in its instruction number 20/2015, dated 29 December 2015, sir. Sir, in this instruction, CBDT instruction number 20/2015, CBDT has required that assessing officer in every case before an assessment is made will issue and shall issue a show cause notice and provide all the material with the show cause notice, sir. So, Shivram sir, I want to say, sir, that reasonable opportunity of being heard requires that assessee is given effective hearing, number one. Number two, effective opportunity to defend his case and present its case. And opportunity of cross-examination is part of reasonable opportunity of being heard. And third, sir, show cause notice, a valid show cause notice, sir. A valid show cause notice, like it is not like this, if I am given a 2-liner show cause notice, in my humble opinion, I have seen in some cases, the show cause notice which we are fighting in High Court and Tribunal, they have given 2-line show cause notice why this addition should not be made. And nothing is given, sir. So in my humble opinion, sir, reasonable opportunity of being heard is a very wide phrase. Clear charge, specific charge, correct charge, and with intelligible and rational material, relevant and intelligible material, sir, must be there in the show cause notice if it is to be called a valid show cause notice. So summing up here, sir, reasonable opportunity of being heard is an integral part in the income tax adjudications and income tax assessments. And income tax assessments are to be well governed by and administered on the basis of principle of natural justice. Impact of violation of principle of natural justice, sir, in my humble opinion, if it is not a writ case, if it is a writ case where we are challenging in writ the validity of a order on ground of natural justice, then probably the court can be valid to set aside that matter to the AO for de novo adjudication. But if it is an appeal, sir, in the ITAT, especially in Income Tax Appellate Tribunal, and where the ground of the assessee, one of the ground of the assessee, sir, is grievance of the assessee is this, that principle of natural justice have been violated in assessment. And despite assessee asking again and again to the AO to please give the back material and cross-examination, etc., in my humble opinion, second innings cannot be given, sir. And when I say second innings, sir, I rely heavily on Supreme Court decision in case of Sona Builders versus Union of India, that 3-judge bench presided by Justice Y.K. Sabharwal, that when an assessment has to be done in a particular time frame and their natural justice is violated and with impunity, then no second innings should be given, sir. Yes, if in writ petition, I agree, sir. If an assessee is challenging the assessment order or an adjudication in the writ petition under Article 226, then the writ court can set aside the matter. But if it is in appeal, especially at second appeal at ITAT level, sir, then in my humble opinion, if principle of natural justice are violated, then addition should be struck down. Assessment should be, and that material should be expunged, sir, which has not tested on principle of natural justice. At least that material should be expunged, and then it should be seen that whether the addition can sustain on its legs or not. So there is another ruling, sir, which the courts have relying time and again, apart from this rulings which I have discussed. 2 rulings I would also like to mention more, sir. One in the case of Odeon Builders. This is the latest Supreme Court decision. from the bench of Justice Nariman Sahab, Honorable Justice Nariman Sahab. The name of the case is Odeon Builders, 418 ITR, page number 315. 418 ITR, page number 315, sir. There again, Supreme Court has emphasized on the principle of natural justice and confrontation of the back material, especially investigation wing material. And next is, sir, Supreme Court ruling in income tax law, which is a leading order, Kishan Chand Chelaram. 125 ITR, 713. So 125 ITR, 713, sir. And this order 418 ITR, 315. Both Supreme Court says that principle of natural justice, if not followed, we can draw an analogy, sir, and principle that the concerned material has to be expunged, has to be excluded, has to be excoriated, has to be deleted from consideration, and then it should be seen whether assessment and addition can stand on its legs or not. So I believe, sir, 7 or 8, I have touched 7 or 8 Supreme Court rulings, 2, 3 you have also touched, sir, CB Gautam, etc. I believe all these rulings combined at least say that principle of natural justice cannot be violated in income tax assessment. And if they are violated in income tax assessment, then the addition made concern can be said to be bad in law and vitiated in law, sir. So with this principle of natural justice, sir, yes, sometimes it depends upon, now there are various cases where tribunal has been setting aside also such cases. Somebody has asked a question that why the tribunal sets aside. So now it depends upon judicial discretion. But yes, I have given my humble viewpoint that if it is the ITAT and I am in second appeal, and despite my repeated request at AO stage and assessment stage and CIT appeal stage, principle of natural justice are not adhered, then ITAT should not give second innings to the revenue, sir. Bombay High Court, sir, because few people are from Bombay, also Thane, etc. Sir, Bombay High Court, a landmark ruling came in the case of HR Mehta. This is a landmark ruling on principle of natural justice from Honorable Bombay High Court, from the bench of Justice Sanklecha Sahab, sir, in the case of 387 ITR 561, 387 ITR, page number 561, sir. And there again, Bombay High Court, sir, said very clearly, it was a case of 148, cash credit, bogus cash credit, alleged bogus cash credit. There, Bombay High Court said it is the duty of the department to itself confront all the material which they have to the assessee in the assessment in reopening, and if they do not do, then entire 148 will be bad. That is the view of Bombay High Court in HR Mehta, 387 ITR 561. So I believe, sir, there are many more things, but I have touched principally all the angles that show cause, valid show cause notice, valid reasonable opportunity of being heard, section 142 subsection 3, Sona Builders versus Union of India, sir. All these things and clear charge, correct charge, and CBDT instruction, everything should be followed. Then only principle of natural justice will be complete, sir. So, sir, this is on the principle of natural justice. As far as my second leg of the discussion is concerned, sir, on 148, sir, in my experience with the Tribunal, High Court, and Supreme Court, one thing which I have learned in the Income Tax Act of 148 is this: that 148 is not an ordinary assessment, it is an extraordinary proceeding. Now, 148 is not equal to 143 subsection 2 at least, sir. Nobody can say that in the normal scrutiny assessment and, sir, reopening of assessment stands both at same pedestal and same level. Because if I am filing a return of income, I am Kapil Goel, sir, then whether to take my return for scrutiny under 143 subsection 2, it is the prerogative of the department and revenue. Now, sir, if my return is not scrutinized for any good reason that my case does not fulfill that parameters of CAS, computer aided selection scrutiny, can it be the simple ground since Kapil Goel return has not been scrutinized and since time limit of 143 subsection 2 has elapsed, so 148 should be allowed without anything more? I believe the answer can be emphatic no, because section 148 is primarily, if I talk about, sir, is fundamentally based on two important jurisdictional facts. First jurisdictional fact in section 148, which distinguishes this provision with other provision, is, sir, that requirement of recording of reasons to believe on the part of the assessing officer. Now, this salutary requirement of recording of reasons to believe under section 148 subsection 2
I believe is of utmost importance and primordial importance. Assessing officer, who is the assessing officer of the assessee, he has to record the reasons in writing before issue of notice under section 148 is the language of section 148 subsection 2. Now, first thing is, sir, there should be reason to believe, and second, sir, point is income escaping assessment. So if there is either there is no reason to believe or there is no income escaping assessment, then provision of 148 cannot be used, sir. If I summarize like this, that either there is no reason to believe, or even if there is reason to believe, sir, but there is no income escaping assessment. So reason to believe leading to income escaping assessment is important jurisdictional fact to initiate and invoke section 148, sir. So 143 subsection 2 is a mere scrutiny provision, sir, mere inquiry provision, sir, mere verification provision, sir. But 148 is not an inquiry provision. 148 is not a verification provision. 148 is not an examination provision. 148 is a provision which requires reasons to believe of the assessing officer, and that to leading to income escaping assessment, sir. So why I am saying, sir, so like this, because many cases, sir, you will appreciate, all of us you appreciate, sir, that many places where 143(2) should have been used and it could not be used for one or the other reason, 148 is issued. Sir, in past 2-3 years, the volume of 148 has increased, in my humble opinion, because of the reason that many cases which deserve to be taken for scrutiny in 143 subsection 2 have been taken under 148, sir. Just because 143 to 6 महीने का time खत्म हो गया, sir. Sir, I humbly believe 148 cannot be used as a tool in disguise or garb to overcome 143 subsection 2, sir. So 148 has to be always distinguished from 143 subsection 2, sir. Normal scrutiny is different and 148 reopening is different, sir. And if there is no reasons to believe, or if there is no income escaping assessment, then 148 cannot be taken and 148 could not be invoked, sir. Sir, as you rightly said, that now so many 148 have been done, and so many last 2-3 years, so many volumes of 148 has increased. And sir, beauty is this, sir, that majority of those 148, I'm saying in humble sense, are done on 31st March, the end day of 6 years, sir. If it is assessment year 11-12, I saw lot many 148 being done on 31st March 2018. If it is 12-13, then a lot many done on 31st March 2019. If it is assessment year 12-13, lot many done on 31st March 2019, sir. Now this assessment year 13-14 के लिए उन्होंने कह दिया कि जून तक नोटिस आ सकता है. Assessment year 13-14, the ordinance has said notice under 148 can be issued till 30th June 2020. So let us see if it remains the same thing, sir. In my humble opinion, the requirement of recording of reasons to believe, number one, and the requirement of reasons to believe on the part of the assessing officer is very important point, sir. Sir, when I say recording of reasons to believe on the part of the assessing officer, one order, sir, which I want to highlight here is the case of Allahabad High Court, Honorable Allahabad High Court, in case of Mohammad Rizwan. Now, in this order, sir, the Allahabad High Court has very extensively analyzed that if reasons are recorded by one officer, let us say Mr. X, who was later found not to be the assessing officer of the assessee, and ultimately, sir, assessment was framed in that case by Mr. Y. Now, Mr. Y was the correct officer. But, sir, neither reasons were recorded by Mr. Y, nor first jurisdictional notice was issued by Mr. Y. Can that proceedings pass the muster of the law? When it is on admitted fact that one Mr. X, who was not the correct officer, recorded the reasons and issued notice under 148, and ultimately the assessment which was framed, sir, was by Mr. Y. The lordships of the Allahabad High Court, that it is the very officer who is the assessing officer and correct officer. Sir, my voice is coming clear, Shivram sir?
Yes, yes, fine.
Sir, the officer who is recording the reasons, the officer who is issuing the notice under section 148 should be the correct jurisdictional officer. And if the officer who has recorded the reasons is found to be not the correct officer, thank you, Sanjeev Anwarji. So, sir, Muhammad Rizwan should be seen, and it is a very important decision that requirement of recording of reasons by the correct jurisdictional officer is a very sine qua non in the 148, sir. Sir, why I am saying? Because on last day, Shivram sir, practically it happens sometimes 31st March, the notice is issued by the wrong officer, and later on they transfer the file to the correct officer in between. And ultimately it happens that the officer who has to record the reasons and has to issue the notice is not issuing, he's just completing the assessment. So in my humble opinion, not only the assessment should be completed by the right officer, but notice under 148 and reasons should also be recorded by the right officer. And for that, I heavily rely upon Muhammad Rizwan and Gujarat High Court Pankaj Bhai Shah case, latest case. Gujarat High Court, this is the latest case, sir, Pankaj Bhai Shah. In my question answer also, I have touched on it. So requirement of recording of reasons by the correct jurisdictional officer and assessing officer, sir, definition is given in section 2 clause 7a. Section 2 clause 7a defines assessing officer. Next point which I want to touch is, sir, that what should be the quality of reasons to believe? Sir, quality of reasons to believe, it is a subjective satisfaction of the officer. But yes, this subjective satisfaction should not be based on suspect, at least. Reason to believe are different from reason to suspect. And reason to believe means an honest belief founded on some tangible material. Now that tangible material has to be narrated in the reasons, and that there should be live nexus between the tangible material and the belief form. Now, sir, if in a given case there is no tangible material at all, or there is no live nexus and connection, rational connection in the belief, then in my humble opinion, 148 reasons will not pass the muster of law. And that is why, sir, even today that view of Justice H.R. Khanna, his lordship, in the case of Lakshmani Meval Das, 103 ITR 437. Now, Supreme Court decision in Lakshmani Meval Das 103 ITR, page number 437, relevant page 457. That what should be the quality of reason to believe, sir? It should not be a product of guesswork. It should not be a product of suspicion. It should not be based on totally on some kind of surmises, etc., sir. It should be based on tangible material and having proper live nexus. If I say something in the reasons, but there is no coherence, there is no cause and effect relationship, sir. I say like this. There are many reasons, sir, in which there is no cause and effect relationship. So, having the requirement of valid reasons to believe, sir, means that it should not be suspicion based. It should be based on proper application of mind, sir. Sir, then it should not be based on irrelevant, extraneous and imaginary grounds, sir. It is a very important point. The reasons cannot be based on irrelevant, extraneous and imaginary grounds. I see a lot of 148 reasons, sir, where irrelevant, extraneous and imaginary and irrelevant points are mentioned. Or if in a case, sir, in reasons relevant point is not seen. Now, what is relevant point, sir? I want to illustrate. Supposingly, I am Kapil Goel, sir. My case is taken up for 148. An assessing authority who records his satisfaction, he says in the reason, Shivram Saab, that I have not filed ITR. But the fact of the matter is this, sir, I am also ITR filer. I have filed ITR and my assessment has also taken place for that year under 143.3. Assessing officer says, मेरा ITR भी नहीं file हुआ, मेरा case assess भी नहीं हुआ, कुछ नहीं हुआ, और I am a total plain assessee. Sir, so I believe, sir, this is a classical case of recording of satisfaction or non-application of mind. Sir, it is a very important fact to be considered and taken cognizance of whether assessee has filed the ITR and whether assessee's case has already been assessed under 143.3 or not. So, what I am summarizing is, sir, the requirement of recording reasons to believe is this, that reasons to believe is antithetical to reason to suspect. Reasons to believe means application of mind based on relevant grounds and not based on irrelevant grounds, sir. Reasons to believe means based on tangible material having live nexus, not having a far-fetched or remote or no cause and effect relationship. So, sir, yes, it can depend upon, sir, case to case and reasons to reasons. But yes, quality of reasons should be such, sir, that subjective satisfaction should be such, sir, that one person who reads it naturally can gather the impression that it is the assessing officer's own satisfaction recorded on his own, in his own manner, sir, by his own pen. So I believe, sir, I have taken a question also that concept of borrowed satisfaction is not there, sir. Assessing officer cannot apply the satisfaction or cannot say I am doing reopening because investigation wing has said me to reopen the case. So I believe, sir, although there is lot of judgments, there is plethora of jurisprudence, but one ruling which I want everyone to take note of, sir, is landmark order. It is a ruling of Supreme Court of India in case of Mahindra and Mahindra. 15 taxman, page number 1. It's a 15 taxman, page number 8, sir. Supreme Court. 15 taxman, page number 1, Mahindra and Mahindra, sir. सर अभी वैसे तो हमने रीजन टू बिलीव को शिवराम साहब कई बार पढ़ा है, बट ये रूलिंग डिफरेंट एंगल देता है सर सुप्रीम कोर्ट का. एंड व्हाई आई एम सेइंग इट्स अ लैंडमार्क ऑर्डर, सर, व्हेन आई वाज प्रिपेयरिंग फॉर दिस वेबिनार लास्ट डे, I found this ruling of Supreme Court in Mahindra and Mahindra, sir, discussing on what should be the quality of discretion when a subjective satisfaction is recorded, and on what grounds a judicial review of a subjective satisfaction can be made. This is why I want to say, sir, in what circumstances a court can judicially review the subjective satisfaction of an assessing officer is Supreme Court has dealt in Mahindra and Mahindra, sir. Sir, reasons to believe are different from reason to suspect. They require independent application of mind. They cannot be based on borrowed satisfaction. And there is a, sir, I have already said there is a lot of jurisprudence, but this order of Supreme Court in Mahindra and Mahindra clearly says if a discretion is exercised by an authority not on its behalf, but on behalf of somebody else, then that discretion will be vitiated by non-application of mind. So, sir, I believe there are a lot of decisions, but 3 decisions will complete my chain of reason to believe. If my viewers can note these 3 citations, sir. ये 3 decision है, sir. Bombay High Court का सबसे पहले ले लेता हूँ शिवराम साहब. This Bombay High Court decision is running into 100 of pages, sir. Goa, this is a Goa bench case of Bombay High Court. In that so-called alleged suppression of export and fraud exports, etc. Mining cases. So Bombay High Court has given a very detailed decision in case of Sisa Sterlite. Sisa Sterlite, sir. And all these are writ petitions order, majority of them, sir. And in Bombay High Court has quashed 148 and has discussed at length and labyrinth manner what should be the quality of genuine reason to believe. The citation of Sisa Sterlite is, sir, 417 ITR, page number 334. 417 ITR, page number 334, sir. एक कंसेप्ट इसमें सर बॉम्बे हाई कोर्ट ने मुझे तो एकेडमिशियन के नाते सीखने को मिला कि दैट प्रिंसिपल ऑफ वेडनेस बुरी रीजनेबलनेस, कि किसी भी 148 को वैलिड 148 कहने के लिए वेडनेस बुरी रीजनेबलनेस का प्रिंसिपल का पूरा होना जरूरी है. मतलब उसमें रीजंस के अंदर रीजनेबल गुण होने चाहिए, रीजनेबल क्वालिटी होनी चाहिए. दैट इज व्हाट बॉम्बे हाई कोर्ट इन दिस इनकम टैक्स लॉ 148 डिसीजन हैज अप्लाइड इन सीसा स्टरलाइट 417 ITR, पेज नंबर 334, सर. सर नेक्स्ट डिसीजन सीसा स्टरलाइट में उन्होंने सारा 148 ज्यादातर क्वाइश ही कर दिया, सर. उन्होंने कहा ये रीजन टू बिलीव ठीक सा रिकॉर्डेड नहीं है, और उसमें उन्होंने चेंज ऑफ ओपिनियन वाला बात भी एनालाइज किया है, फर्स्ट प्रोवाइजो टू सेक्शन 147 भी एनालाइज किया है, बहुत कुछ एनालाइज किया. मेन पोर्शन रीजन टू बिलीव पे है कि व्हाट शुड बी द क्वालिटी ऑफ रीजन टू बिलीव. सर दूसरा फैसला जो मैं डिस्कस करना चाहता हूं, सेकंड पॉइंट, सर, ऑन रीजन टू बिलीव. सर दिस इज अगेन ए लैंडमार्क ऑर्डर, सर, पटना हाई कोर्ट. The citation of this Patna High Court is, sir, 266 taxman, page number 506. 266 taxman, page number 506. सर इसके फैक्ट्स ये थे पटना हाई कोर्ट के कि एसएससी ने एग्रीकल्चरल इनकम अपना रिटर्न में दिखाया, उसका केस सिक्योरिटी में नहीं आ पाया. डिपार्टमेंट ने रीजंस में कहा कि हमारे को सीबीडीटी ने कहा है कि ये जो रिटर्न एग्रीकल्चरल इनकम जिसमें ज्यादा दिखाया है रिटर्न में, उसको 148 में ले लो, और जहां 143.2 नहीं हो पाया है। तो सर ऐसा कहते हुए डिपार्टमेंट ने 148 का रीजंस रिकॉर्ड कर दिया। पटना हाई कोर्ट स्पीकिंग थ्रू जस्टिस ऑनरेबल जस्टिस हिज लॉर्डशिप ज्योति सरन हैज क्वैश्ड 148, और डिपार्टमेंट ने सर बहुत ज्यादा एम्फेस्टिकली ये कहा था साहब कि हम तो राजेश जवेरी पे रिलाई करते हैं और रेमंड वुलन मिल्स पे। उन्होंने कहा भैया राजेश जवेरी पे रिलाई करते हैं वो सही है, बट रीजंस टू बिलीव बता दीजिए कि रीजंस टू बिलीव है। द पटना हाई कोर्ट हैज सेड सर, द जजमेंट ऑफ पटना हाई कोर्ट सेज कि 148 कैन नॉट बी डन फॉर द पर्पस फॉर विच 143.2 इज मेड। दिस इज द बोन मैरो एंड सबस्ट्रेटम ऑफ द ऑर्डर सर। ए लैंडमार्क फाइंडिंग कि 148 आप इसलिए नहीं कर सकते कि आप पता ढूंढने के लिए कि इनकम एस्केप हुई नहीं हुई। 148 means that you know reasons to believe are there that income has escaped assessment. So Justice Jyoti Saran says, sir, in Patna High Court, that yes, 148 is still qualitatively different from 143 subsection 2. 148 cannot be used for the purpose of 143. Third decision, sir, of Karnataka High Court. Why I am mentioning? क्योंकि सर बहुत जगह डिपार्टमेंट ये कहता है कि अभी आपका केस सिक्योरिटी में तो नहीं आया है और आपका रिटर्न सिक्योरिटी होने से रह गया है, इसलिए हम 148 करते हैं। बट बहुत सारा हाई कोर्ट इस बात को नहीं मानता अभी भी। They say just because 143.2 is not done, it does not mean that AO has reasons to believe, valid reasons to believe that income has escaped assessment within the meaning of 148. सर तीसरा डिसीजन जो मैं बोलना चाहता हूं, that is from Karnataka High Court, and the citation of Karnataka High Court is C Mahadeva sir, 404 ITR 147। ये सब लेटेस्ट ऑर्डर्स हैं सर, सब लेटेस्ट है, एक साल के ही। 404 ITR 147। अब यहाँ क्या कहता है सर रीजंस टू बिलीव में एओ साहब? वो कहते हैं साहब आपका कपिल गोयल हैज मेड वन इन्वेस्टमेंट इन द इमूवेबल प्रॉपर्टी, बट कपिल गोयल इज शोइंग वेरी लेस इनकम करस्पॉन्डिंग इनकम इन द ITR। सो एओ बिलीव्स कि नहीं, कपिल गोयल माइट हैव invested in the property from undisclosed sources. High Court quashed it, sir. That source of investment in a property can be revenue source also and can be capital source also. So where these reasons to believe are validly founded? So Karnataka High Court, Patna High Court, Bombay High Court, sir. Quality of reasons to believe means reasons to believe, sir. Not something where in the garb of 148, 143.2 is done, sir. Sir, somebody asked me a question in seminar and webinar in last days. Mr. Goel, in a demonetization case, sir, I am taking a practical case. A case where cash was deposited, huge cash was deposited in financial year 16-17. That case could not come under scrutiny, sir. Now, jurist asked me, professional brother, Mr. Goel, can 148 be done? Just because 143.2 nahi hua or time khatam ho gaya, to check the source of cash deposit in the bank account? Sir, my answer is no. Merely to inquire into the source of the cash deposit in the bank account, which is a disclosed bank account in the ITR and final accounts, 148 should not be used, sir. Yes, Mr. Anwar, NDTV says that does not mean that they say, but anyhow, sir, I am coming on NDTV. Sir, now Supreme Court has given a decision, landmark decision of this in the case of New Delhi Television Limited of 3rd April 2020. And I have also, sir, many times, at least 20-30 times I have discussed in my webinars. So NDTV पढ़ते अभी 20-25 बार तो मैं पढ़ चुका हूँ सेमिनार में सर इसको। तो सर अभी क्या है कि न्यू दिल्ली टेलीविजन लिमिटेड, one important thing, sir, at the outset I want to say to my viewers, which I noticed, that this is a case of a writ petition, was a case of a writ petition where SSC NDTV challenged the reopening under 148 before Delhi High Court. Delhi High Court confirmed reopening, sir, in the writ. That's why in the Supreme Court, SSC NDTV went to challenge the decision of the High Court. So when we have to study the decision of NDTV in Supreme Court, we have to be very mindful what were the observations of Delhi High Court in the underlying impugned order, which was authored by Justice Ravinder Bhatt, as his lordship then was, and the order of Justice Deepak Gupta Sahab in the Supreme Court decision of 3rd April, sir. So what I want to say, sir, that this is important point, that in the writ petition now, Supreme Court has found reopening to be defective and invalid for violation of first proviso to section 147, principally speaking. So this is in writ now. Sometimes we see, sir, many high courts in the country say we will not go into this arena of 148 adjudication because alternative efficacious remedy is there. I believe, sir, one can take a sound note of this point, that NDTV case was not an appeal case. It was a case over writ petition, and Supreme Court, while deciding the 3 issues framed before the lordships, has found reopening to be invalid on ground of violation of first proviso to section 147. And that too in writ petition. So, in writ proceedings. So what I want to say is, sir, the Supreme Court decision in case of NDTV, the facts of this case, sir. Because as you rightly say, when you touch this point, sir, how to read a precedent or how to get a ratio decidendi and how to separate the ratio decidendi from obiter dicta. So as a student of law, in humble manner, it is always very important to know how to read a precedent. And it has not to be read like a statute. It is very clear, sir. So NDTV case was for assessment year 8-9. The reopening was done, sir, on the end of the fag end of the sixth year, I said 31st March 2015. The assessment for this assessment year 8-9 was completed in 143.3 in 2011. Now it is a case of 8-9. Reopening was made on 31st March 2015 after the end of 4 years from the assessment year. And the earlier assessment of 489 has already been completed in section 143 subsection 3. So in this background, sir, when we go to the reasons which were recorded in the case of New Delhi Television Limited, sir, 2 important reasons, sir, Chairman sir, are given in the reasons to believe. One, the AO assessing officer, learned assessing officer, relies upon the tax evasion petition received by the assessing officer of the company from some shareholders, minority shareholders. And second, sir, of the company. And second, sir, these findings of the DRP and the subsequent assessment order of assessment year 9-10. So two reasons weigh with the assessing officer in the reasons to reopen the case and invoke the jurisdiction of 148. First, tax evasion petition TEP, and second, sir, subsequent assessment year findings in AY 9-10 of the assessment order and DRP. Although DRP was subsequently pending challenge in ITAT, sir. So, in this background, sir, the Honorable Apex Court framed 3 issues. First, whether the revelations which were made, fresh revelations which were made in the subsequent assessment year, can be a ground to record the reasons and can constitute tangible material within the meaning of section 148 was the first issue, sir. Whether subsequent assessment year findings can clothe the assessing officer for AY 8-9 to reopen the case under 148. And whether in this question, sir, they touched upon whether prohibition of change of opinion will come into play or not. The doctrine of change of opinion. Second aspect, sir, which the Honorable Apex Court framed in this Supreme Court decision, second issue for the lordships. So second issue was whether these reasons which were recorded in this instant case are satisfying first proviso to section 147 or not. Now, first proviso to 147, sir, I always feel is a very important protection given to the taxpayer, that when a reopening is made after the end of the 4 assessment years and already scrutiny assessment has taken place in 143 subsection 3, then assessing officer in the reasons have to display and demonstrate how the disclosure made by the assessee earlier was not a true and correct disclosure, sir, within the meaning of first proviso to section 147. So the second aspect which was framed by the Supreme Court was whether the reasons in the NDTV case fulfilled the mandate and prescription of first proviso to section 147 or not. Sir, third and last point which was framed by the Supreme Court for their consideration was violation of principle of natural justice, sir, as you also touched, Shivram sir. And there The Supreme Court was framing this issue, sir. When in the reasons, only 2 points were recorded, only 2 aspects were noted, only 2 tangents were taken. Can a different tangent be introduced, any new tangent be introduced in the order disposing the objections against reasons to believe for the first time? So third aspect which the Honorable Apex Court framed was, sir, while disposing the objections against the reasons to believe, whether the assessing officer can introduce something which was not part of the reasons as communicated to the assessee in the first place, and whether it amounts to violation of principle of natural justice or not. Sir, lastly and curiously, they have given one liberty to the assessing officer, because the assessing department was very heavily saying कि साहब हमारा ये reopening अभी नहीं ठीक है, तो हमारा second proviso to 147 भी है. तो जज साहब ने सर लास्ट पैराग्राफ में लिखा है, सुप्रीम कोर्ट ने, ऑनरेबल सुप्रीम कोर्ट ने, कि आपको चाहिए इफ लॉ अदरवाइज परमिट्स यू कैन रीओपन द केस, इफ अदरवाइज लॉ परमिट्स यू मे रीओपन द केस. लिबर्टी दिया है. तो सर नाउ आई विल कम टू दीस 3 aspects one by one. What Supreme Court has given the answer in the NDTV case on all these 3 aspects. And as you said, sir, as a student of law, I am reading the decision like that only, precedent, in the manner in which precedent has to be read. Keeping in mind the principles which Chairman Saab and Supreme Court, sir, has many times led, how a precedent has to be extracted for ratio decidendi. Sir, पहले aspect का उत्तर Supreme Court ने ऐसे दिया कि they found, their lordships found, yes, subsequent assessment year revelations which gave a different picture, although transaction was not new, transaction वो पहले से चला आ रहा था जैसे था, तो उन्होंने कहा कि if it subsequent revelations are made in the subsequent assessment year orders, then it can clothe the assessing officer with the reasons to believe, and it will not be hit by the doctrine of change of opinion. And I want to take 2 points here, sir, from academical point of view. One, there are earlier 2 Supreme Court decisions, sir, which in detail touches on principle of change of opinion, that reopening on mere change of opinion is not allowed. What is mere? कि सिर्फ change of opinion के base पे 148 नहीं हो पाएगा. That is first ruling in a detailed manner, where Supreme Court, after the amended law of 1989, Kelvinator case, 3-judge bench, Justice Kapadia, Honorable late Justice Kapadia, 320 ITR 561, 320 ITR panna number 561, sir. So Kelvinator was, sir, has been one of the authoritative pronouncement that reopening cannot be made on basis of mere change of opinion. Sir, mere बहुत important word है इसमें, और mere को आगे कोर्ट्स ने बताया है कि मेयर का मतलब उन्हीं फैक्ट्स के ऊपर जो उस समय थे उसी पे आप रीओपन नहीं कर सकते. सो कैल्विनेटर इज वन ऑफ द इंपॉर्टेंट डिसीजन दैट सेइंग दैट चेंज ऑफ ओपिनियन का बेस पे आप रीओपन नहीं कर पाएंगे. सर, जस्टिस आर के अग्रवाल इन सब्सिक्वेंट डिसीजन ऑफ टैक्सपेन, TECHSPAN, टैक्सपेन 404 ITR पन्ना नंबर 10. सर, दिस इज a latest order of Supreme Court again. Taxpan 404 ITR page number 10, that Justice R.K. Agarwal followed Supreme Court ruling in the case of Kelvinator, and found again said yes, merely on the basis of change of opinion reopening under section 148 is not allowed. So yes, there are already Supreme Court decisions on change of opinion, sir. 2 of them I have noted, Kelvinator and Taxpan. Now this NDTV case, in my humble opinion, is different from the facts in the case of Kelvinator and the case of Taxpan, if I analyze like this, क्योंकि वहां पर कोई ऐसा रिवीलेशन नहीं था. Here subsequent assessment order gave some fresh revelation, sir. So I believe, sir, this case of NDTV and their Supreme Court decision is right, and I humbly concur with that. Yes, it is not purely a case of change of opinion. When subsequent assessment year order is there and subsequent assessment year DRP findings are there, which give a different picture of the transaction, and some tax evasion is pointed out. So mere change of opinion is not here, sir. Second aspect which I want to touch here is, sir, and which I want, sir, in the concluding session you should also know, just highlight, because I believe their Supreme Court has not touched it. Sir, interplay between 148 and 263. अगर कोई चीज असेसिंग ऑफिसर के सामने थी सर, और असेसिंग ऑफिसर रिमेन oblivious of it and did not and overlooked it and did not apply mind to that aspect and framed my assessment under 143.3. So is it a case to be first taken for 263, or it can be taken even under 148 and it is the choice of the department? Sir, I believe various high courts, at least 3 high courts I know, sir. Telangana, Andhra Pradesh, Delhi High Court, and one more high court is there. I have given my question answer, sir. Sir, there they say if something is aptly covered in section 263, which is the power bestowed on principal CIT to correct the order of AO, then that thing cannot be done by AO under 148. So interplay 148 का 263 के साथ एक महत्वपूर्ण एंगल और है सर, एनडीटीवी के केस में भी जो टच नहीं हुआ. So in my humble opinion, as far as first aspect of the Supreme Court ruling is concerned, sir, yes, it is not a case purely based on mere change of opinion. There were subsequent revelations on the facts already also on record, but interplay between 148 and section 263 is yet to be seen, sir. Whether it was a case fit for revision by CIT under 263, or even AO could do it under 148, or it is the choice of the assessing officer. Sir, there is an apex court decision by Justice Ranjan Gogoi, authored by Justice Ranjan Gogoi Saab, in the case of Amitabh Bachchan, 384 ITR, page number 200, that there has to be a healthy balance maintained between various powers given in the law to the assessing of to the revenue authorities. Sir, 148 अलग है, 263 अलग है, 154 अलग है. तो ये और एक एकेडमिक एंगल है सर जो मुझे लगा इंपॉर्टेंट है, जिसमें पढ़ाई हो सकती है. और दूसरा महत्वपूर्ण विषय सर जो एस्पेक्ट सुप्रीम कोर्ट ने एनडीटीवी में लिया कि व्हाट इज द एप्लीकेबिलिटी ऑफ फर्स्ट प्रोवाइजो टू सेक्शन 147. सर, as I humbly said that lot many reopening take place at the end of the 6th year only, so सब में ज्यादातर 4 साल खत्म हो गए होते हैं. सर, उसमें मैं 2 बातें रेज करना चाहता हूं सर. In Supreme Court decision, the Honorable Lordship has said that the duty of the assessee ends with making primary facts, disclosure of primary facts. If assessee has disclosed all the primary facts in his knowledge, then duty of the assessee to make the further disclosure is not there. And it is up to the assessing officer, if he wants to have more, then he can ask more details. And there the Supreme Court has followed in NDTV case the earlier Constitution Bench decision in case of Calcutta discount 41 ITR. What is the disclosure quality referred in first proviso to section 147? So, sir, Supreme Court says disclosure contemplated in first proviso is disclosure of primary facts, not the disclosure of the secondary facts. So, sir, here I want to touch 2 important academic points more. I feel Supreme Court is absolutely right. Yes, assessing officer in the reasons recorded has to pinpoint that how disclosure made by the assessee earlier is faulty disclosure and defective disclosure. And if this finding is not coming, allegation, proper allegation in the reasons is not coming, sir, I believe then entire reopening will be vitiated. Fulfillment of first proviso to section 147, in my humble opinion, in the reasons itself is must. सर, एक विषय है जिस पे आपका भी हम मार्गदर्शन चाहेंगे कि डिस्क्लोजर जो फर्स्ट प्रोवाइजो बोलता है उसका क्या स्टेज तक है. क्या मेरा ड्यूटी असेसी के नाते डिस्क्लोजर का आईटीआर तक है, या उसके बाद मेरा ड्यूटी असेसमेंट में भी अपने आप डिस्क्लोजर करने का है ही बोले इन एंडलेसली. जस्टिस रविंदर भट्ट इन द दिल्ली हाई कोर्ट डिसीजन सर has followed another decision here in NDTV case. एक होंडा सीएल का ऑर्डर है सर दिल्ली हाई कोर्ट का, होंडा सीएल, दैट सेज कि असेसी का ड्यूटी डिस्क्लोजर करने का सिर्फ रिटर्न तक नहीं है, असेसमेंट में भी उसको सारा डिस्क्लोजर करना है जो चाहिए. सर, अब ये कैसे पता चलेगा कि कौन सा डिस्क्लोजर करना चाहिए और नहीं करना चाहिए और जो असेसिंग ऑफिसर को चाहिए. सर, इन माय हम्बल ओपिनियन as an academician also, sir, the duty of disclosure contemplated in first proviso should be restricted to statutory disclosure contemplated in ITR and tax audit report, etc. It is not like this. In assessment also, I should voluntarily keep on giving details to the assessing officer. So I want that area should be touched by you, sir, also. Now, Delhi High Court said that yes, disclosure should go beyond written also. In my humble opinion, that is not the correct implication of first proviso to section 147. Disclosure stage has to be decided, sir. Disclosure stage and disclosure boundaries. Third aspect, sir. So second aspect was the sir. Second aspect of the Supreme Court ruling. First aspect went against the assessee. कि reason to believe तो है और change of opinion नहीं है. Second aspect went in the favor of assessee. Yes, in this case, the Supreme Court found the reasons to be defective and the invalid on ground of this violation of first proviso to section 147. Third aspect, sir. Supreme Court highlighted that yes, assessee should be given all the reasons, correct reasons and complete reasons. And if a department and revenue in its own choice gives selected reasons to the assessee in 148 proceedings, then while disposing the objections against the reasons, assessing officer cannot travel beyond what is written in the reasons, sir. What is given in the reasons, communicated in the reasons. So I believe it is again vindication of that healthy principle, sir, जो बॉम्बे हाई कोर्ट ने बहुत पहले हिंदुस्तान लीवर में लिखा था, कि that reasons to believe cannot be improvised and modified like this and cannot be subsequently altered. So I believe third aspect of the Supreme Court is on this point, sir, that assessing officer, if has relied upon limited points in the reasons, then while disposing the objections challenging reasons, assessing officer cannot go beyond what is given in the reasons. And Supreme Court found it will be again violation of principle of natural justice. Sir, this case has been filled with turns and twists. कि दिल्ली हाई कोर्ट के सामने असेसी का बहुत बड़ा आर्ग्यूमेंट ये था कि साहब हमारे केस के अंदर रीजंस के अंदर फर्स्ट प्रोवाइजो के ऊपर असेसिंग ऑफिसर ने प्रॉपर एलिगेशन नहीं दिया है. ASG appearing in Delhi High Court argued from department side कि साहब जहां हम ट्रांजैक्शन को शैम बोलते हैं, बोगस बोलते हैं, वहां हमें अलग से लिखने की जरूरत नहीं है कि ये डिस्क्लोजर सही नहीं था. That was department argument. Delhi High Court went with department. But I believe now, sir, Supreme Court has made it very clear, like the light of the day, that if a reopening after 4 years has to pass the muster of the law, and especially where 143.3 has been done earlier, then mere incantation of the words of first proviso will not suffice. Incantation. उसको बताना भी पड़ेगा assessing officer को reason recording satisfaction में कि कैसे disclosure सही नहीं था. Mere कह देने से, sir, I believe that jurisdictional fact will not survive or will not exist. So, sir, last point, liberty given by the Supreme Court, sir. Sir, Supreme Court has given one liberty. That is definitely any. If this would not have been given, I believe still the department could have taken 148 if the other grounds are there and law otherwise permits. So liberty should not be treated as direction in my humble opinion, because liberty is something different and direction is something different. It is a mere liberty. If law permits, then the case can be taken up for 148 is the Supreme Court's last paragraph, sir. So summing up, sir, I believe the entire bone marrow of the case is this, that first proviso to section 147 is a very important safeguard, statutory safeguard for reopenings made after the end of 4 assessment years, especially where 143.3 has already been done. So NDTV should be read in this manner, sir. I believe, as you also said. 2 things I have separately added: interplay between 148 and section 263, and second, disclosure stage of disclosure contemplated in first proviso to section 147. Sir, you will appreciate there is an explanation to section 147 which says that, explanation 1 I am referring particularly, explanation 1, which says that कि assessee ने अगर एक assessment में खाते पेश कर दिए, books of accounts पेश कर दिए हैं, तो उससे ये नहीं माना जाएगा कि उसने सारा disclosure कर ही दिया है necessarily. Sir, I believe explanation 1 cannot be made as a basis to say कि जो मैं ITR में disclose कर रहा हूँ, front पे टैक्स ऑडिट रिपोर्ट में कर रहा हूं, फाइनल अकाउंट में कर रहा हूं, वो भी असेसिंग ऑफिसर ने नहीं देखा है या वो भी नहीं देखा जा सकता था. सो एक्सप्लेनेशन 1 टू सेक्शन 147 सेइंग दैट if something is put in heap of documents, legion of documents, an assessing officer cannot trace it, that explanation 1 cannot apply, sir, where I have made the disclosure in ITR, tax audit report, audited final accounts. So explanation 1 to section 147 has to be rationally viewed.
इट कैन नॉट बी सेड कि सारा डिस्क्लोजर जो मैंने किया है वो सब असेसिंग ऑफिसर ने नहीं देखा है, एंड फॉर दैट एक्सप्लेनेशन वन इन माय हम्बल ओपिनियन कैन नॉट बी रिलाइड इन ए कार्टे ब्लैंच मैनर. So sir, I thought that yes, all these three issues, sir, you will also touch interplay between section 148 and 263, stage of disclosure, and this explanation 1 to section 147. Now sir, next point, one of the very important areas of this, sir, reopening, which is further creating practical problems, Chairman Sahab, is explanation 3 to section 147, sir. Sir, what is the scope of 148? If I am Kapil Goel, my case is reopened under section 148 on one particular transaction, on one particular aspect, that source of cash deposit has to be seen. Sir, my case when reopened, sir, assessee Kapil Goel went to the assessing officer and explained, "Ki sahab, I sold this immovable property in this financial year, and this cash I got from the sale deed, and this I deposited in my bank account." Sir, assessing officer agreed on this aspect. Both were ad item कि हाँ, कपिल गोयल जी झूठ नहीं बोल रहे हैं और ये पैसा उनको प्रॉपर्टी बेचने से मिला. सर, अभी असेसिंग ऑफिसर साहब क्या कहते हैं कि नाउ आई विल चेक मिस्टर गोयल whether you have paid capital gain on this property or not sale. Sir, my question to myself and my viewer is this: can it be done on the self same reasons, on these reasons, where the basic point was to check the source of cash deposit, which stood explained to the satisfaction of the AO? Can this twist be made कि आप वो source of cash deposit से capital gain assessment में जाना चाहते हैं? सर, मेरा ओपिनियन ये है कि एक्सप्लेनेशन 3 जो 147 में ऐड हुआ था फाइनेंस एक्ट 2009 से, उसमें ये लिखा है सर कि अगर असेसिंग ऑफिसर चाहे तो ही कैन गो बियॉन्ड द रीजंस टू बिलीव आल्सो, बट देयर आर स्पेसिफिक चेक्स एंड बैलेंसेस. नंबर 1 कि एक तो उस पॉइंट पे एडिशन होना चाहिए सर जिस पॉइंट पे रीओपनिंग हुआ था. अभी उस पॉइंट पे अगर एडिशन ही नहीं हुआ तो आपके यहाँ बॉम्बे हाईकोर्ट ने, जेट एयरवेज ने बोला, फिर दिल्ली हाईकोर्ट में रैनबैक्सी के केस में जस्टिस सिकरी ने बोला सर, हिज लॉर्डशिप 336 ITR पन्ना नंबर 136. तो सर ये बात तो सेटल लॉ आई बिलीव अक्रॉस हाई कोर्ट्स की, इफ देयर इज नो एडिशन ऑन द पॉइंट ऑन व्हिच केस इज रीओपन, देयर कैन बी नो अदर एडिशन सर, एंड प्रोसीडिंग्स हैव टू बी टर्मिनेटेड एंड ड्रॉप. सर, माय सेकंड पॉइंट इज इंपॉर्टेंट सर, कि इवन इफ देयर इज एनी एडिशन ऑन द पॉइंट ऑन व्हिच रीओपनिंग इज मेड, जैसे मेरे केस स्टडी में सोर्स ऑफ कैश डिपॉजिट है, उसमें मान लीजिए कुछ अमाउंट का एओ साहब ने एडिशन कर भी दिया सर, what is the safeguard that 148 will not become like 143(3) normal scrutiny assessment? An assessing officer will not issue a wholesale questionnaire in the 148 proceedings. Sir, practically it happens that in all 148 questionnaire comes, and in that questionnaire bulk detail is asked. My question is this, whether in the light of explanation 3 to section 147, which says that yes, AO can go beyond the reasons to believe, provided subsequently he comes to the notice. Sir, the word used is subsequently he comes to the notice. Sir, can assessing officer in a roving manner or fishing manner ask the assessee to give, भैया आप सब कुछ ले आइए, आप अपना सारा बही खाता ले आइए, आप अपना सारा डेटर क्रेडिटर ले आइए, आप अपना सारा बैंक स्टेटमेंट ले आइए, आप सब कुछ ले आइए? सर, वो जबकि सब कुछ मेरा ITR में डिस्क्लोज्ड है जिस दिन मेरा केस 148 में आया था, और कुछ नया जानकारी एओ साहब के पास 148 के दौरान बाहर से अंदर से कहीं से नहीं आया है. सर, मेरा ओपिनियन ये है कि एक्सप्लेनेशन 3 कैन बी यूज्ड ओनली व्हेन सम सब्सिक्वेंट इंफॉर्मेशन कम्स टू द असेसिंग ऑफिसर आफ्टर रीओपनिंग ऑफ द केस. अगर जो कुछ है वो सब कुछ ऑलरेडी अवेलेबल था जिस दिन मेरा रीजंस पहले रिकॉर्ड हुआ, जब प्राइमरी रीओपनिंग हुआ सर, ओरिजिनल इनिशियल रीओपनिंग हुआ, अगर उसी समय सब कुछ था, तब आप उन विषय के ऊपर असेसी से जानकारी नहीं मांग सकते हैं जो आपकी नॉलेज में सब पहले से ही थे, ITR के माध्यम से, बैलेंस शीट के माध्यम से. सर, आई फॉट ए केस एंड द ITAT सर रिसेंटली सर, वेयर द इशू वाज लाइक दिस कि 148 वाज मेड ऑन बोगस शेयर कैपिटल एलिगेशन ऑफ 10 लाख रुपीज. सर, उस साल में असेसी के पास 3.5 करोड़ का शेयर कैपिटल आया था चेयरमैन साहब. असेसिंग ऑफिसर ने सर 148 के दौरान असेसी को बोला, भैया 10 लाख तो हम ऐड करेंगे ही करेंगे, आप एक काम करिए, बाकी का जो आपकी बैलेंस शीट में आ रहा है बढ़ा हुआ, उसका बारे में बताइए. असेसी ने कहा कि साहब एक्सप्लेनेशन 3 कैसे लागू होता है?
तो उन्होंने कहा नहीं, हमारे पास 148 करने के बाद पावर है, इट इज लाइक ए नॉर्मल असेसमेंट, वी कैन आस्क एनीथिंग. सर, इन माय हम्बल ओपिनियन, दिस इज रॉन्ग अप्रोच. Explanation 3 to section 147 does not make 148 like a de novo scrutiny assessment. और इसके लिए सर आपके बॉम्बे आईटीटी से, सर हमारे बॉम्बे आईटीटी से एक ऑर्डर आया है, बहुत लैंडमार्क ऑर्डर है, जूलियट, JULIET, जूलियट लिमिटेड. Juliet Limited is a very detailed order, sir, on explanation 3 to section 147. Yeah, how far explanation 3 can allow AO to go beyond what is written in reasons? It says, sir, कि AO साहब can go beyond reasons only when something extra comes to his knowledge during 148A. And secondly, sir, this may be noted कि वो जो एक्स्ट्रा चीज पे जानकारी मांगना चाहते हैं उसके लिए अलग से 148 का एक नोटिस इश्यू करना जरूरी है. रीजन रिकॉर्ड करना जरूरी नहीं है, बट 148 का नोटिस देना जरूरी है. सर अब 148 का नोटिस तो नहीं दे पाएंगे क्योंकि वो तो 6 साल ऑलरेडी खत्म हो चुके हैं. तो इसका मतलब क्या ये कहा जा सकता है कि जिस केस में 6 साल खत्म हो गए, जो 6 साल के एंड में रीओपनिंग की गई है 31 मार्च को, वहां अधिकारी असेसिंग ऑफिसर साहब रेवेन्यू कैन नॉट गो बियॉन्ड रीजंस एट ऑल because they will not be having power to issue me second 148 notice, sir, quad that item. So there I believe, sir, for this angle कि separate 148 का notice चाहिए होगा, and for that Bombay ITT Juliet Limited can be referred, and Delhi High Court in Ranbaxy also said it, sir. 336 ITR 136, 336 ITR 136. Justice Sikri said if AO has to go beyond reasons, then he has to issue a notice, separate notice of 148. And that is applied, sir, in my one recent argued case where we got, sir, relief of 50 crore rupees, sir. Assessing officer ने रीओपनिंग 5 लाख के लिए किया था चेयरमैन साहब, और एडिशन कर दिया 55 करोड़ का. तो अभी ट्राइब्यूनल ने एक ऑर्डर लिखा है, सर, दिल्ली आईटीटी में. आई हैपन टू आर्ग्यू दिस ऑर्डर इन केस ऑफ देवकी नंदन बिंदल. दिस इज अ वेरी इंपॉर्टेंट ऑर्डर, देवकी नंदन बिंदल, सर. There Mr. Bhavnesh Saini, speaking for the Delhi bench of ITT, has said yes, if 148 separate notice is not given, then that second issue addition cannot be made. So I believe, sir, explanation 3 to section 147, I am summarizing, does not make in 148 akin and at par with normal scrutiny assessment. Assessing officer cannot go beyond reasons in normal circumstances and ordinary circumstances unless something extra comes to his knowledge after reopening, and which was not available to him at the time when he recorded the reasons. And third, he has to issue a separate 148 notice, sir. Sir, now at the end, before closing, moderator साहब कितना समय हो रहा है मेरे पास?
10 minutes.
10 minutes, सर. एक सर, आप शिवराम साहब आज साथ हैं, सर, इसलिए मैं ये विषय एक और उठाना चाहता हूं, और जैन साहब भी हैं. सर, एक इलेक्ट्रॉनिक एविडेंस का डिसीजन है. इलेक्ट्रॉनिक एविडेंस का जो प्रोविजन है सेक्शन 65B इंडियन एविडेंस लॉ, सर, कि कोई भी इलेक्ट्रॉनिक एविडेंस तब तक यूज नहीं होगा जब तक सर्टिफिकेट ना आए. सेक्शन 65B वाला इलेक्ट्रॉनिक एविडेंस का एक सर्टिफिकेट होता है, सर, 65B, सेक्शन 65B ऑफ इंडियन एविडेंस लॉ. सर, बहुत जगह जो डिपार्टमेंट आजकल एविडेंसेस यूज करता है, डिपार्टमेंट जैसे 148 में भी, सर, वो इलेक्ट्रॉनिक एविडेंस होता है, सर. तो किस स्टेज पे असेसी इनकम टैक्स प्रोसीडिंग्स में ये इलेक्ट्रॉनिक एविडेंस का सर्टिफिकेट मांग सकता है, सेइंग दैट इट इज आल्सो एप्लीकेबल इन इनकम टैक्स लॉ इफ एट ऑल? सो कुछ ऑर्डर्स, एक ऑर्डर मेरे नॉलेज में आया है कोचिन बेंच का, जहां कोचिन बेंच ऑफ आईटीटी हैज फॉलोड सेक्शन 65B सुप्रीम कोर्ट डिसीजन एंड सेइंग दैट कि सिंस डिपार्टमेंट हैज नॉट गिवन सर्टिफिकेट required in 65B, they have set aside the matter to the AO for re-examination and de novo examination in light of Supreme Court decision on section 65B. So how far the jurisprudence will change, sir, in light of this new piece of provision section 65B, that in case of electronic evidence, certificate from competent person is required? In my humble opinion, sir, if I see the rulings of Supreme Court and try to make a unbiased analysis of it, it says that yes, in income tax law also, in across law, 65B is a very important provision, and the person who is wanting to use electronic evidence, burden is on him to prove this certificate, sir, give this certificate. Last point, sir, of my today's discussion. Sir, in lot many cases, and I have taken one of the question in my question answer, sir. सर, बहुत सारा रीओपनिंग में क्या देखा चेयरमैन साहब कि 148 में जो रीजंस मेंशन है उसमें एक पहला लाइन लिखा है कि सर्टेन इंफॉर्मेशन हैज कम फ्रॉम इन्वेस्टिगेशन विंग। सर उसमें ये नहीं लिखा कि वो कौन सी इंफॉर्मेशन है, कब आई है और कब एओ साहब को प्राप्त हुई है। मेरा कहने का मतलब तात्पर्य है सर कि अगर एक रीओपनिंग के लिए जो इंफॉर्मेशन यूज की जा रही है रीजंस में, वो ऑलरेडी अधिकारी के पास, रेवेन्यू अथॉरिटीज के पास उस समय उपलब्ध थी, दैट वाज अवेलेबल सर एट द स्टेज व्हेन 143(3) मेरा पहले हुआ जब, तो क्या वही स्टेल इंफॉर्मेशन जो डिपार्टमेंट के पास, रेवेन्यू अथॉरिटीज के पास मेरे ओरिजिनल असेसमेंट के समय थी, क्या उसी इंफॉर्मेशन के बेस पे स्टेल इंफॉर्मेशन आई एम सेइंग सर 148 अलाउड है सर? I found one Delhi High Court order, sir, penned down by Justice Ravinder Bhatt when he was there in the High Court, sir. Now, this is a very interesting decision to read, sir. In case of Raslika Trading, 365 ITR, Raslika Trading, 365 ITR, 477, Raslika Trading. Now, in this order of Raslika Trading, sir, Delhi High Court, 365 ITR, sir said that if an information was available to the assessing officer at the time when the assessment was originally hitherto completed in 143(3), self same information Jain Sahab cannot be used in 148. It is a tantamount to using of stale information. So sir, angle of stale information is also relevant. और ये हमें तभी पता चलेगा चेयरमैन साहब जब हमें ये बताया जाएगा कि वो इंफॉर्मेशन डिपार्टमेंट के पास कब आई और वो उसका कंटेंट क्या है और वो करदाता को, असेसी को मिले सर उसकी कॉपी, रेलेवेंट एक्सट्रैक्ट। अभी अगर मुझे सर वो चीज मिलेगा ही नहीं जो रीजंस में रेफर्ड है, तो मैं ये कैसे पता लगाऊंगा कि कैसे तो वो इंफॉर्मेशन स्टेल इंफॉर्मेशन है सर और कैसे तो वो इंफॉर्मेशन मेरे केस को इंप्लीकेट करता है। तो बहुत सारे लोगों का सर ये भी सवाल है, अभी भी आया है कि साहब वेदर द असेसी इज हैविंग राइट टू आस्क द अंडरलाइंग इंफॉर्मेशन व्हिच इज रेफर्ड इन द रीजंस टू रीओपन ए केस। सर इन माय हम्बल ओपिनियन आंसर इज यस, and that is coming out from Supreme Court ruling somewhere in NDTV case also, but there is a direct decision, sir, which is a very detailed decision of Delhi High Court in case of Saab Infrastructure Limited, sir, you know this, and Bombay High Court has also followed it. Saab Infrastructure, Delhi High Court 398 ITR 198, 398 ITR, page number 198, Saab Infrastructure. Sir, in this order, Delhi High Court has given SOP, Standard Operating Procedure on 148. कि जब भी कोई रीजंस असेसी को मिलते हैं तो असेसिंग ऑफिसर को जब रीजंस सप्लाई करना है असेसी को, तो दिल्ली हाई कोर्ट सेज सर जस्टिस मुरलीधर हिज लॉर्डशिप कि साहब आपको उसमें रीजंस के साथ उतना कॉपी भी देना है इन्वेस्टिगेशन विंग रिपोर्ट का और स्टेटमेंट्स भी देना है और वो डॉक्यूमेंट भी देना है जो आप रेफर कर रहे हैं, सो फार एज इट इंप्लीकेट्स द असेसी। सर ये बहुत कम बार होता है कि जब असेसी को वो कागज मिलते हैं जो असेसिंग ऑफिसर रीजंस में रेफर करता है, जबकि असेसी बार बार मांगता रहता है दे दीजिए दे दीजिए दे दीजिए, वो नहीं देते। तो मेरा ओपिनियन ये है सर कि वो जो पहले हमने डिस्कस किया, आपने भी बोला क्या सिर्फ उसका जूस करक्स दे देने से मुझे पता नहीं चलता कि क्या इंफॉर्मेशन थी, उसके क्या कंटेंट्स थे और उसका नेक्सस और कनेक्शन असेसी के साथ रैशनल कनेक्शन क्या है भी या नहीं है, वो इंफॉर्मेशन ट्रस्टवर्दी है या नहीं है। तो ये सब चीजें तो तभी होगी सर जब साफ इंफ्रास्ट्रक्चर वाला जो गाइडलाइन फॉलो होगा कि दैट असेसी इज gracefully provided with all those material in principle of natural justice which is referred in the reasons to reopen a case of a taxpayer. Sir, in lot many penny stock cases and share capital cases where 148 has been used, the allegation is this that they are bogus accommodation entries and that is primarily founded on investigation being recommendation. Now question is this sir, why not assessee can be confronted with all those relevant material so far as it relates to the assessee, not full material. So I believe, sir, yes, that material assessee has a right and assessee should always ask in the reopening in every letter. मैं तो सर अपने ऑफिस में बोलता हूं कि हर एक लेटर के अंदर आप मांगिए कि साहब जो रीजंस में आपने रेफर किया उसका कॉपी दीजिए, क्योंकि वो आगे नहीं देंगे तो आगे मुझे अपील में उसका बहुत हेल्प मिलेगा. And that is why all those rulings of Supreme Court, sir, will help us, which you have also told and which I have also discussed, sir. The violation of principle of natural justice in 148 like this will vitiate and will invalidate the entire, fulminate, I am using the word, fulminate the entire proceedings. So in 148, I believe, sir, I am ending that burden to prove that income has escaped assessment lies on the, primary burden lies on the revenue authorities. and that has to be proved only by a cogent material is confronted to the assessee by principle of natural justice, sir. And that is what Bombay High Court also said in HR Mehta 387 ITR 561. So with these words, sir, I have tried to cover maximum from my side, sir. Rest, if anything is left, with great humbleness, I request, as your ardent follower, Jan Sahab, and you can add, sir. I always find it very, sir, blissful that all of you listen me and give me so much of blessing, sir. And we can take all the questions as per moderator Sam and sir, you decide, sir. Thank you, sir.
Thank you.
नारायण साहब आपका आवाज नहीं आ रहा है सर, अनम्यूट करिए सर.
हेलो हेलो हेलो, अभी आ रहा है
सर? अब थोड़ा अब आ रहा है सर, भाई साहब आ रहा है.
अच्छा, ऐसा है कि आपने इतने कम समय में ऐसा टॉपिक है नेचुरल जस्टिस और रीअसेसमेंट दोनों, कि इसमें तो ज्यादा 3-4 घंटा कम से कम आपके पास होना चाहिए था, लेकिन इतने कम समय में आपने गागर में सागर की बात जो है आपने सब चीज बताने की चेष्टा की. एंड वी आर very privileged to have you as a speaker today. Now, whatever time we have got, next 15 minutes we would like to use for some questions and answers. Many people have sent the question even in advance, and then we will be benefited with kind concluding remarks by our respected chairman. So I am posing some questions what we have received. Many of these are very simple questions, and whatever cases you already referred, these are also dealt by that. But still, for the benefit of the questioners, one is, you see, when unquoted shares which are brought forward from earlier year and are sold during the year, sale proceeds are issued by account by check, and buyer is regular income tax assessee. Now, whether the sale proceeds can be added in reassessment on the plea that the source of payment is through receipt from entry operators. That is the allegation of the department, and the relevant assessment area is assessment at 1213, where source was not required to be proved. This was the question. Kapil bhai.
चेयरमैन साहब आप बोलेंगे सर प्लीज? सर मैं बोलूं आप बोलेंगे सर प्लीज?
आप बोलिए, you please reply.
जैसे सर आप, मेरा ओपिनियन ये जैन साहब, इसमें हम्बल ओपिनियन, कि that firstly this allegation of department, this is the allegation that this money is a tainted money because entry operator has given it, or it is routed through entry operator. Now sir, I believe सेक्शन 102, 103 और 106 ये अलग इनकम टैक्स एक्ट के सेक्शन नहीं है, इंडियन एविडेंस लॉ के सेक्शन है जिनका बहुत इंपॉर्टेंट रोल है यहाँ पर. सेक्शन 102 सर, चेयरमैन साहब, 103 और 106 इंडियन एविडेंस लॉ. कौन प्रूव करेगा कि मैंने एंट्री ली है नहीं ली है सर? मैं तो ये कह रहा हूँ जैन साहब, मैंने शेयर सेल करे हैं, मेरे इन्वेस्टमेंट में आ रहे थे, जिस साल लिए जब इन्वेस्टमेंट में आ गए, जब बेचे इन्वेस्टमेंट से हट गए और ऑडिटर ने ऑडिट कर दिया बैलेंस शीट को, आईटीआर में मैंने दिखा दिया उसको. तो अभी क्वेश्चन ये कि मैंने तो जो फैक्ट्स था वो अपनी नॉलेज में वो बता दिया है. डिपार्टमेंट ये चाहता है इसको कहना कि ये एंट्री है या सेसी का अपना पैसा है. तो सर स्पेसिफिक बर्डन ऑफ प्रूफ, बहुत सीरियस बर्डन ऑफ प्रूफ है सर. मेरा बर्डन डिस्चार्ज हो गया जब मैंने ये सब कागज दे दिए, बैलेंस शीट, फाइनल अकाउंट, परचेज ऑफ शेयर का प्रूफ और सेल ऑफ शेयर. इतना कागज देने के बाद जैन साहब, परचेज, सेल, बैंक स्टेटमेंट, ऑडिटेड फाइनल अकाउंट दे दिया सेसी ने फॉर परचेज ऑफ शेयर. अब आप देखिए, और सेल ऑफ शेयर. अब डिपार्टमेंट चाहता है इस बात को, फैक्ट को एग्जिस्टेंस में लाना कि ये अकोमोडेशन एंट्री है या ये एसएससी का ओन अनडिस्क्लोज इनकम है. सर इसके लिए सेक्शन 106 और 102 और 103 इंडियन एविडेंस लॉ में मेरे ख्याल से बर्डन डिपार्टमेंट के ऊपर है सर, बहुत सीरियस. और वो बर्डन सिर्फ एक एलिगेशन से डिस्चार्ज नहीं होगा जी, उसके लिए मटेरियल चाहिए. मटेरियल क्या चाहिए सर बताइए? अब मटेरियल पहले तो वो एंट्री ऑपरेटर आइडेंटिफाई हो कि वो रामलाल है, श्यामलाल है, नंबर 1. उसने किस प्रोसीडिंग में बोला, सर्वे में बोला, सर्च में बोला, कहां बोला, किसको बोला, किसके सामने बोला, कब बोला, तो उसका स्टेटमेंट चाहिए. उसके स्टेटमेंट में क्या क्वेश्चन पूछे गए उससे, मेरी ट्रांजैक्शन से संबंधित या उस ट्रांजैक्शन से संबंधित या जनरली, और कैसे वो स्टेटमेंट एसएससी को, जो जिसका केस रीओपन किया गया एंट्री ऑपरेटर का, उसके स्टेटमेंट के बेस पे उसको इंप्लीकेट करता है. क्या नेक्सस है स्टेटमेंट के बीच में और बीच में और एसएससी के केस के बीच में सर? तो 4 चीजें हैं सर. पहला, who is the entry operator? What is the material found from the entry operator in his investigation? क्या incriminating कागज मिले हैं उसके पास से? सर उनका स्टेटमेंट को कोर्ट ने बोला इंक्रिमिनेटिंग डॉक्यूमेंट नहीं है, सिर्फ स्टेटमेंट ऑफ एंट्री ऑपरेटर विल नॉट बी काउंटेड एज मटेरियल फाउंड फ्रॉम द एंट्री ऑपरेटर। सर मटेरियल अलग होता है, स्टेटमेंट अलग होता है। तीसरा कि उस स्टेटमेंट को 132 सबसेक्शन 4 में रिकॉर्ड किया गया है, 133 में रिकॉर्ड किया गया है। चेयरमैन साहब बहुत सारे केसेस बॉम्बे में, एक आदमी है प्रवीण कुमार जैन, में नाम लेके बोलता हूं, उनके बेसिस पे रिकॉर्ड रीओपन हुए, और वहां बॉम्बे आईटीटी ने, मेरे ख्याल से मेरे पास 1 दर्जन ऑर्डर की नॉलेज है सर, कि जहां कहा गया कि वो स्टेटमेंट रिट्रैक्ट हो चुका है और वो रिट्रैक्टेड स्टेटमेंट के बेस पे केस रीओपन हो गया सर। तो बॉम्बे आईटीटी, आई बिलीव जैन साहब हैज क्वेश्चन लॉट ऑफ 148 where one allegation was this that assessee has received alleged accommodation entry through some Praveen Kumar Jain, and this is on record that statement has been found to be retracted। तो सर स्टेटमेंट की कॉपी, इंक्रिमिनेटिंग मटेरियल क्या मिला, और सबसे आखिरी में और सबसे इंपॉर्टेंट उसका क्रॉस एग्जामिनेशन।
जी
सर ये चारों माला पूरी हो जाएगी तभी गाड़ी आगे बढ़ेगी सर।
ये जो लास्ट
अभी आप इसमें से कोई भी माला में से मोती हटा देंगे, आप सोचिए, आप नाम ना बताएं, आप स्टेटमेंट ना दें, आप मटेरियल ना दें, आप क्रॉस एग्जामिनेशन ना दें, और फिर भी अपनी चॉइस से ही कहें कि मैंने, और मुझे कहें कि आप प्रूव करो कि तुमने एंट्री नहीं ली है। सर ये तो मानसूर क्लास पे जैसे जाने जैसी बात हो जाएगी सर।
Thank you. This last question was asked by CS Santosh Rungta. Now I am coming to other question. That is in many cases 147 action, as you also said in your deliberation, is being taken on the basis of borrowed reason, like information from investigation wing. And I am adding with that the assessment, the reassessment are being completed with lack of independent mind or application of proper reasons. So if this can be done, because in Kolkata many cases are based on simply mentioning that information has been received from investigation.
Not only in Kolkata, ये sorry to say I am on record sir, ये तो जो ट्रेंड है ना, मैं इसको वायरस नहीं बोल रहा हूँ, I am not saying it is virus, sorry, ये जो ट्रेंड है ये पूरे इंडिया में एक जैसा चलता है सर, हम ह्यूमन बींग्स है ना, तो इसका आप ये मत कहिए कलकत्ता में ऐसे रीओपन होता है, हमारे पास भी दिल्ली में जो भी साहब बोल रहे थे चेयरमैन साहब, बॉम्बे में सब जगह रीओपनिंग में बहुत जगह यही लाइन लिखा होता है, इंकेंटेशन बोलते हैं। तो सर आर्ग्यूमेंट ये है मेरा सर, इसमें 15 टैक्समैन पेज नंबर 1 महिंद्रा एंड महिंद्रा, ये जो मैंने आज के लिए अलग निकाला डिसीजन, 15 टैक्समैन पेज नंबर 1 सुप्रीम कोर्ट महिंद्रा एंड महिंद्रा, दिस सब्जेक्टिव सेटिस्फेक्शन इज ए डिक्टेटेड सेटिस्फेक्शन, इज ए बोरोड सेटिस्फेक्शन, सुप्रीम कोर्ट ऑफ इंडिया महिंद्रा एंड महिंद्रा 15 टैक्समैन पेज नंबर 1, and this subjective satisfaction will be invalid। वैसे तो बहुत सारे ऑर्डर्स हैं जैन साहब, और आपकी ट्राइब्यूनल के तो बहुत सारे कोलकाता बेंचेस के ऑर्डर्स हैं जहां उन्होंने बोरोड सेटिस्फेक्शन के ऊपर बहुत सारा 148 क्वेश्चन किया है। बट आई हम्बली बिलीव चेयरमैन साहब, this is a new finding which I found Mahindra in Mahindra. There is a very good paragraph written on how discretion of subjective satisfaction should be used by any authority, and there Supreme Court has quoted very healthy principle from administrative law, that if any satisfaction, subjective satisfaction is based on discretion dictated by somebody else, then it will be counted as it is a faulty exercise of discretion. So Jan sir, that answers your point.
Yeah, that next question is that in assessment year 12-13 in the ITR, we were required to only mention one bank account in which we wanted the refund if there was a claim of refund. Now the party mentioned one bank account, but he was having 5 bank accounts. The ITO reopened the assessment on the basis that there were other 4 accounts, and he wanted to add all the bank balances and all this. Though those are already reflected in the balance sheet.
Sir,
this is the question.
Sir, again it is a 148. See, I believe sir, there have been lot of 148 which we have argued, and which many of us might have argued. Sir, cash deposit in the bank account has become one of the basis for reopening. I believe this is what is Curie is asking, sir. There is one
this
bank.
Is not cash deposited. The only one bank account was mentioned in the ITR, because that time in assessment of 13, the requirement was of only mentioning one bank account where I wanted my refund. All bank accounts were not required to be mentioned.
ठीक है, right sir. अभी वो 148 के reasons में क्या लिखता है assessing officer?
Other 4 accounts he's talking about.
So but he says that merely because
that is in my balance sheet, all accounts are mentioned.
तो आपका कहना क्या मतलब ये है, या मतलब क्यूरिस्ट का कहना है कि सर कि दी लर्नेड क्यूरिस्ट सेज कि साहब जो मैंने और बैंक अकाउंट्स आईटीआर में डिस्क्लोज नहीं किया,
चीज उन्होंने कहा कि दे देगा।
Please put on the mic of Kamalji. Goel, please.
Sir, I am saying that is it the query of the learned curious that since other bank accounts are not mentioned in the ITR, so 148 is made.
Yes.
Sir, see, that is why, sir, I told about this order of Karnataka High Court in C. Mahadeva, 404 ITR 147. 404 ITR page number 147. Now there, Jain Sahab, one of the argument to support 148 by the department was this कि assessee ने सर ये नहीं बताया कि वो जो प्रॉपर्टी में इन्वेस्टमेंट किया है उसका सोर्स क्या है. तो कर्नाटका हाईकोर्ट सेज कि भैया आपको सोर्स ऑफ इन्वेस्टमेंट सब चीजों का आईटीआर में अगर कॉलम नहीं भी था और तो भी आपको नहीं बताया तो उससे आप रीजंस टू बिलीव दैट इनकम हैज एस्केप्ड असेसमेंट और ये अनडिस्क्लोज इन्वेस्टमेंट है या अनडिस्क्लोज सोर्सेज से ये कहां से निकल के आ रहा है
जी.
I believe this query can be directly addressed by this Karnataka High Court decision of 404 ITR 147.
Fine.
ITR में अगर कॉलम नहीं था फिर तो बात ही खत्म होगी. मेरे कहना ये कि सर अगर था भी जैन साहब और मान लीजिए किसी ने नहीं भरा तो उसके लिए सजा डिफेक्टिव रिटर्न की है 139(9) में जो अदरवाइज प्रोविजन है आपको पता है. बट उसके लिए चेयरमैन साहब ऐसा नहीं है कि आप उस नॉन फाइलिंग ऑफ कॉलम इन द आईटीआर से ये रिजल्ट निकल जाएगा कि दैट माय इनकम हैज डीम्ड टू हैव एस्केप्ड असेसमेंट merely because I have not filled a particular column in a ITR. Supposing I am having a tax exempt income, मेरे को मेरी माता जी ने गिफ्ट दिया 50 लाख रुपए का सर और मैंने वो गिफ्ट जैन साहब आईटीआर में नहीं दिखाया तो क्या वो और पैसा जमा करा दिया मेरी माता जी ने जो मुझे दिया बैंक में मैंने तो क्या वो बाद में जाकर रीओपन इसी बात पे हो जाएगा क्योंकि मैंने आईटीआर के कॉलम में नहीं दिखाया था उसको कि एग्जेम्प्ट इनकम है. That is my point.
We move to next question. That is one from one chartered accountant Rajaram Chaudhary ji that an assessee had taken loan of rupees 50 lakhs. The AO got information that the bank account of loan creditor is not disclosed in his ITR. The loan creditor has confirmed the transaction that he has given the loan, he has given the bank account, he has given one affidavit, but the department is ignoring the same. And addition has been made 50 lakhs.
Sir, again, it is a classical case of this is again a classical case of non-application of mind and making addition on extraneous material. जो मैंने अभी आपको महिंद्रा बोला ना सर, वो सब जगह लगता है. It is exercising the discretion on basis of irrelevant ground and extraneous ground and ignoring relevant ground. अब मैंने आपसे लोन लिया जैन साहब, अब मेरे बड़े भाई हैं, आप मुझे चेक से लोन दे देते हैं और मैं आपका कंफर्मेशन दे देता हूं, आपका पेन नंबर दे देता हूं, आपका एड्रेस दे देता हूं, तो उसके बाद तो प्राइमरी बर्डन शिफ्ट हो गया, सेकेंडरी बर्डन डिपार्टमेंट पे आ गया, उसको थ्रो बैक करना पड़ेगा ना बर्डन मेरे पर. सेक्शन 68 इज हैविंग कंसेप्ट ऑफ शिफ्टिंग ओनर सर. अदर टाइम हमने डिस्कस किया था जब डिमोनेटाइजेशन का चैप्टर डिस्कस किया था कि सेक्शन 68 हैज कंसेप्ट ऑफ शिफ्टिंग ओनर्स. Yes, first onus is on the person who has taken the loan, but once he has discharged that primary onus, then secondary onus is on the department to say I am wrong and to again throw back the onus on the assessee. I believe if it is not done, then entire addition is vitiated by non-application of mind.
There is another small question that is written.
नारायण जी प्लीज आप ये जो अभी चैट पे आए वो लीजिए, जो पहले आए हुए वो लोग नहीं है यहाँ पे, जिनके चैट पे आए वो क्वेरीज लीजिए.
ठीक है, ये लास्ट क्वेश्चन आई एम पोजिंग.
नहीं सर ये टाइम जा रहा है, जो बेचारे आए नहीं उनको छोड़िए, जो बेचारों ने डाला है
कौन सा बोल रहे हैं सर, आप बताइए ना क्या पूछ रहे हैं सर.
ठीक है, देयर इज वन श्रीराम पुराणिक. He says that he filed return under section 148 and there were some hearings in response to 142. Then the file was transferred. Is it mandatory to issue notice under section 143(2) by the new assessing officer?
सर मेरा कहना ये था, जब मैंने अभी इसको बोला बीच में कि जिस ऑफिसर के पास फाइल ट्रांसफर हुआ है जैन साहब
जी,
पहली बात तो जब बीच में फाइल ट्रांसफर हुआ है उसका क्या रीजन था. अगर वो ऐसा था कि वहां करेक्ट ऑफिसर जिसने पहले नोटिस दिया वो करेक्ट ऑफिसर नहीं था, बाद वाला ऑफिसर करेक्ट ऑफिसर था, तो वहां तो मैंने डिसीजन गुजरात हाईकोर्ट का दिया है सर पंकज भाई शाह
जी
जी राइट ऑफ एंड मोहम्मद रिजवान. The right officer should record the reasons, correct officer, and correct officer should issue the notice. तो एक बात तो वो है. दूसरी बात ये है सर, जो 143 सबसेक्शन 2 का कानून है, अदरवाइज सुप्रीम कोर्ट होटल ब्लू मून से लेकर अभी जो लक्ष्मण दास खंडेलवाल इज द लेटेस्ट ऑर्डर 417 ITR लक्ष्मण दास खंडेलवाल, that yes, in 148 proceedings, if I have filed a 148 return, then 143(2) has to come. Now I believe the query is this कि जो ऑफिसर जिसने मेरी असेसमेंट करनी है सर, अगर वैलिड ट्रांसफर हुआ है सर बीच में, जैसे होता है कि ड्यू टू क्या नाम वर्क एलोकेशन की वजह से, तो वहां 143(2) जो पहले वाले ऑफिसर ने दे दिया है तो दोबारा देने की जरूरत नहीं है. आई बिलीव आई एम क्लियर सर.
Right.
अगर पहले वाले ऑफिसर ने जिसने 148 शुरू में दिया था और रीजंस रिकॉर्ड किए थे वो करेक्ट ऑफिसर नहीं था, मैं बार बार बोल रहा हूं, दैट इज मोस्ट इंपॉर्टेंट सर.
There is one question from Mr. Vijay Gangwani that can assessment be reopened under section 148 on ground of audit objection, and can we get relief in appeal on this ground?
सर दिल्ली हाई कोर्ट का सबसे लीडिंग, इसमें दिल्ली हाई कुछ नहीं देखने की जरूरत है. दिल्ली हाई कोर्ट का और एक CBDT का सर्कुलर, दिल्ली हाई कोर्ट का सन फार्मास्यूटिकल का ऑर्डर है, रिपोर्टेड ऑर्डर सन फार्मास्यूटिकल. जैन साहब, अगर ऑडिट ऑब्जेक्शन कोई फैक्चुअल एक्यूरेसी इनएक्यूरेसी बताता है, डेफिशिएंसी, तब तो रीओपन हो सकता है ऑडिट ऑब्जेक्शन पे. बट अगर ऑडिट ऑब्जेक्शन कोई लीगल इंटरप्रिटेशन बताता है नहीं ऑन मटेरियल ऑलरेडी अवेलेबल, देन इट विल बी कॉल्ड एज चेंज ऑफ ओपिनियन ओनली सर. Two things are there. Audit objection can be there in a case where any factual error is noticed, factual deficiency is noticed, factual lacuna is noticed. And second, sir, where any new interpretation on law is suggested. In second case, audit objection cannot be the basis of 148 because it will be counted as change of opinion. Audit objection cannot suggest new interpretation, na sir?
Yeah.
So that is what Delhi High Court has said in case of सन फार्मास्यूटिकल. आपको पता है इसमें प्रैक्टिकल एंगल है सर, कि कई बार जब पहले ऑडिट ऑब्जेक्शन आता है, सन फार्मास्यूटिकल में गार्गिया जी, ईस्टर्न इंडियन एक्सप्रेस सब कुछ लिखा हुआ है. आई एम टॉकिंग अबाउट, मैं हर एक जिसमें नहीं बोल सकता. तो दिल्ली हाई कोर्ट का सन फार्मास्यूटिकल में आज तक का सारा लॉ डिस्कस्ड है सर ऑडिट ऑब्जेक्शन पे. उसमें एक बात है सर जैन साहब, जो गुजरात के डिसीजन से निकल के आई कैडिला हेल्थ केयर से, सबसे इंपॉर्टेंट, उसमें ये फैक्ट था कि सर एक ऑडिट ऑब्जेक्शन आया एओ साहब के पास. एओ साहब ने कहा कि आई एम नॉट एग्रीमेंट विद व्हाट ऑडिट ऑब्जेक्शन इज सेइंग, और उन्होंने मना कर दिया कि नहीं रीओपनिंग नहीं होना चाहिए. फिर भी बाद में रीओपन हो गया केस सर. तो कोर्ट ने बहुत सारे हाई कोर्ट के ऑर्डर्स आ गए कि ऐसा केस में अगर ऑडिट ऑब्जेक्शन की बेस पे रीओपनिंग होगा तो वो इट इज ए क्लासिकल केस ऑफ एक्टिंग ऑन बोरोड सेटिस्फेक्शन एंड डायरेक्शन ऑफ ऑडिट विंग. तो वो आपको कॉरेस्पॉन्डेंस देखना पड़ेगा फाइल में इंस्पेक्ट करके कि बैकग्राउंड क्या है.
Thank you. Friends, I understand there are many more questions, but the time is not permitting us. And there are two very nice write-ups. I had occasion to read part of that. And those will be kindly put up by Shri Keval Vijay Ramani in the text Gyan group. So kindly go through it properly. Whatever questions possibly everybody is having in mind, those will be.
Sorry जैन साहब, एक अभी जो जिन्होंने ऑडिट ऑब्जेक्शन का क्यूरी पूछा है ना, उनको अभी आपको मैं भेज दूंगा. मद्रास हाईकोर्ट ने चेयरमैन साहब अभी लॉकडाउन के पीरियड में मद्रास हाईकोर्ट ने अभी अप्रैल 2020 लेट दे हैव रिटन एन डिसीजन कवरिंग एंटायर लॉ इन इंडिया ऑन ऑडिट ऑब्जेक्शन और क्वेश किया एक रीओपनिंग. अभी अप्रैल में आया ऑर्डर. आई एम नॉट रिमेंबरिंग द नेम ऑफ द डिसीजन, बट दैट इज द लेटेस्ट डिसीजन ऑफ मद्रास हाईकोर्ट.
Okay, that also I will share. And yes, now with our utmost thanks to the learned speaker, Shri Kapil Goel bhai, may I request our chairman, Dr. K. Shivram Saab, to kindly give the concluding remarks, and then we will have vote of thanks and conclude. Shivram Saab. शिवराम साहब का माइक चालू कर दीजिए.
हमने कर दिया है, वहां से नहीं हो रहा. शिवराम सर, प्लीज ट्राई अनम्यूटिंग देयर. वी आर डन इट हियर. शिवराम सर, प्लीज ट्राई फ्रॉम नाउ. वी आर हियर.
Button unmute. Okay.
Yeah.
Okay.
Yeah.
Yes.
In fact, that the time is out now. This is subject, it go on, and that I don't know, Mr. Goel had covered nicely almost all the issues. In fact, I should thank the Goel. Many of the, in fact, many of the case laws what he referred. In fact, I was not knowing. I must confess that many. In fact, I become more, the knowledgeable after hearing you some of the issues. Thank you, Goel, very much. Okay. One more thing I thought, let me just one or two issues only. I will not go on
Please.
talking on that.
Please, sir.
One is, you have covered about, that your electronic evidence.
Yeah.
But, recently I come across the judgment of Supreme Court. What it says, it is a discretion of the court to admit or not to admit. The court feels that certificate is required, they have to. If the court feels that no, it is not required, they may go ahead. That is one is concerned. But interesting, I'll tell you one interesting case. It came from Mumbai Tribunal, where we are arguing the matter 148. The recorded reasons were not given, but they recorded in the computer. Ultimately, department showed before the tribunal. We said that we are not given recorded reason. Copy they are given. Ultimately, department filed affidavit before the tribunal stating that no, we are recorded in the computer. But ultimately, tribunal said that nothing the recording computer, not the recording of this. You have to actually record and submit. That judgment reported Muller and Phillips. They said that recording computer is not sufficient. Is concerned. Now, issue what you raised is as regard, Praveen Kumar Jain. You are right. 6 months back, almost all the tribunal Mumbai decided in favor, but now the trend has changed. Now all these matters comes, members say that not before me, not before me. We don't know after lockout where it will go, and after lockout, how the court will take the trend that we have to see and we have to judge it. The trend in the earlier is may not good law. I don't know how the new thinking of the court.
Sir, NDTV से strength मिलेगा नहीं मिलेगा sir?
NDTV, yes, I think possibly we are right. But one thing, just Goel, please consider one more judgment, Bombay Court, Swastik reality.
Sir.
That dealing with 68, I am telling you.
Sir.
Where that initially the statement was made of the party, I am giving the bogus.
Sir.
Then he retracted. After
Sir.
2 years retracted.
Sir.
Then in the statement was given, and ultimately addition was made. In fact, everything confirmation is that everything is there. Tribunal we lost. Matter went to the High Court. High Court also saying nothing doing, though it is nothing but book entries. Therefore, the entire edition is confirmed. This is how sometimes court will look into the various aspects concerned, as you rightly put, and then it has to be seen you have read the judgment, you have to see the fact, then you have to apply the case with this. One more thing, let me share with you, not on the law, on practical aspect. How to read the judgment, like this. This is the what, they argued before Supreme Court Justice Shah. Mr. R.J. Kola is the senior of Mr. Dastoor, When you argue before the court, the department argued first. Then the judge, Chief Justice told Mr. Kola, we have read the judgment. Department argued very length. We are fully convinced with the judgment, need not argue the matter at all. Then Kola replied, Chief Justice, nothing doing. You are read your point of view. Department read from their point of view. Now I will read my point of view, and then you decide. Ultimate judgment in favor of the SSC. Telling depends upon how we read the judgment from our point of view, department from their point of view. That is how ultimately we have to read the judgment. Ultimately, each case has to be tested own facts. There is no on the law is concerned. Of course, no doubt we could not discuss section 151. We could not discuss the other issues of like merger. All these common issues are in 148. I think it is by I think we'll take it with some other time. The Goel is my only request. Goel will be. Is it possible to write article on this instead of presentation? Of course, you already done it. Like natural.
Sir, I made an article, sir.
What you made all?
It is in article form only, sir.
It's article form only. Okay.
I also, sir, I am your student, sir.
No. Please send us a copy so that the others can also benefit out of that. That will be the great help to those who have those.
Both these papers are in form of article only.
Very good. Can you please send us that copy so that will help us to circulate it very large.
Sir, I will forward it. I have received it. I will forward it.
Thank you very much. Okay, now with this background, I think so what I feel is that in fact one advice will be all these participants is concerned. Ultimately, that while giving the reply to the AO or 148, whatever may be, don't jump on the law. First, give on the facts. Thereafterwards, law will take care of automatically. when the matters come the police concern. With this, I think thank you very much. Of course, we could not discuss your NDT everything, where we see some other occasion in some other forum. In fact, I am really, thank to Mr. Ramani, in fact, when Ramani told me to chat, bola yaar, it is, don't trouble me. Then he told me, nahi, yaar, Goel is speaking, Nayan Jain moderating. Bola, then I will yes karke.
Sir, you are Bhishma Pitama for us, sir. Always.
In fact,
Thank you, Shivram Sahab.
Obliged,
May
obliged,
I
sir.
request Sri R.D. Kakra
thank
to
you.
kindly propose formal vote of thanks. Mr. R.D. Kakra.
Thank you.
Unmute.
Yes,
हो गया बोलिए.
please start. Mr. Kakra.
Friends,
Yeah.
you all witness a historic webinar today, May 20th, 2020. And it's immense pleasure and proud privilege for me to extend vote of thanks on behalf of all organizers. Thank you, Kapil Goel ji, for excellent, outstanding and superb deliberation. We all enriched. You covered all the angles of reassessment under income tax. वर्तमान में कोविड-19 एरा में आपने जैसे ज्ञान की गंगा बहाई है, इसके लिए आपका बहुत बहुत आभार. In my views, brothers, as like corona warriors, all the speakers, organizers, associations played the role of worthy webinar warriors. We all applaud Kapil Goel ji as worthy webinar warrior. Friends, in this lockdown period, the webinar series helped the professional community immensely to enrich and update the knowledge of professional. And today's Kapil ji's contribution is unique one. For that, I sincerely thanks to our chairman, Dr. Shivram Sahab, and moderator, Professor Sri Nayan Jain, and their word of wisdom. My gratitude to Mr. Nankani and other past president of AIFTP, Secretary General Mr. Samir Jani, galaxy of past president of DTPA for their gracious presence. Last but not least, Mr. Vijay Kevalamani, the head one of organizer, for his untiring efforts. Big thanks to all participants. Thanks all of you once again.
सर नारायण जैन साहब वो भेज दिया मद्रास हाईकोर्ट का डिसीजन मैंने आपको सर.
Sir? Huh?
मद्रास हाईकोर्ट भेज दिया सर आपको.
अच्छा.
मद्रास हाईकोर्ट का डिसीजन 7 मई 2020 का.
Kakra ji, thank you very much. And once again, my personal thanks to Vijay Bhai and his team for giving me the opportunity. And Vijay Bhai may be willing to make some announcements. Vijay Bhai, please.
Thank you, sir. Before ending, some future announcements. Friends, Friday we have another lecture on nitty-gritties of Form GSTR Form 9 and 90, that is Annual Return and Audit under GST Act by CA Mayur Parekh from Mumbai, and the chairman will be Advocate ML Patodi ji from Kota.
Very good.
And I would like to personally thank Narayan Jain sir for conducting the session beautifully. My personal thanks to Shivram sir for accepting the invite, and also to Kapil Goel ji for accepting our invite, and Kakra ji for connecting to Kapil Goel sir. And looking forward to you all. My also thanks to Nankani ji for being present, and our president of Tax Friends, Asam ji Tekchanani, being present over here, and all the pastors. Thank you, friends. Looking forward to see you on Friday.